levy tax on the VAT element also, because matter, if your lordship, this is the main issue, your lordship. According to in the position they are saying, so we have to file counter.
Can there be a tax on tax? Basically, that's what it is.
This is.
But our contention is that we have not taxed it on that 4%. What he has done is one of the petitioner has levied tax at 4%. Our contention is that it will be 12%. Regarding 12%, he has no objection. But their grievance is that, the 100 rupees is the product, 4% is the tax. It will be 104.
Correct.
Now, if it is 12%, it will be 112.
Correct.
Now, on that 8%, we are going to levy tax. Their contention
so
is
you
that
have
we are levying tax 8% on 104, not in the 100 rupees.
It has to be only on 100 rupees, not 104.
But
The
we have
difference.
denied that. Reply on a fixed money not civil consideration. Court issue, my lord, we have denied it.
This is a question of. This is not a question of fact. This is a
It's
question,
not a question of
Question of law, but
Well-
since they have filed, client insisted for filing, that's why. Otherwise, this is a legal issue.
So basically, the product is 100 rupees.
Say it is 100 rupees.
Say VAT is what 12%.
12, they only levy.
VAT will have to be on that 100 rupees.
But they are
But
charging
you are-
on 104.
You want that 12% on 112.
Miles.
That's their contention.
They are
What is your
charging.
contention?
They are charging 104.
100.
No, their contention is that, my lord, on 104 we are levying. If we take 4% is the tax, they have levied.
Yes, 104.
So 8% now we are going to levy on 100 and
104.
No, but where did that 4 rupees come from?
My lord, what happened?
4% tax.
4% tax. And now you are going to levy 12 on
12%.
Okay, that 4% is what tax?
VAT, your lordship.
Where
VAT. What has happened, my
the
lord?
balance
As
amount
we
is 8% now. It should be
we levy tax
Okay, should have been 12.
So 8% we are going to levy
Then
now.
it would have to be on that 100.
100, but they are charging on 104.
That we have denied.
So the initial VAT charge had been made at the rate of 4%.
Yeah.
Mistakenly.
The percentage is right.
Interpretation, my lord.
By 4%.
My-
Having data found out that it should have been 12%, you are going to make 12%.
Difference of
12%, but since 4% has already been paid,
So on
so it will
8%.
be on 12 minus 4.
8% on 100
So 8, whether it should be on 100
or 100.
or 104.
this is the question.
What is there to decide?
Amount is, my lord.
They have given certain calculations to my lord.
No.
On-
We are more interested in your calculation.
No, we have denied that.
I said you have denied that.
Yeah, we have denied that.
Okay, you
We
have denied.
are saying that it is on 100. They are showing certain calculations.
Okay, they are saying
Yeah,
that it is
we have stated only 8% we are my lord going to levy.
Difference of tax, your lordship.
Huh?
Difference of
Correct, but it's on the rate basically. It's on whether you are saying that they are charging on 104.
oh,
You are saying that it is a tax on tax.
tax on tax.
But
Yeah.
they are saying that no, it is not a tax on tax. It is a
That we have
tax
to demonstrate
on
by-
the cost price.
That we have to demonstrate before your lordship whether it is 104 or 100. If it is 104, my lord, they can't. If it is 100, my lord, they can. The difference.
On 16, man.
When can you file your affidavit?
My lord, 2 weeks, my lord.
Why?
It will come from Bombay, your lordship. That's it,
So with regard to that aspect,
my lord.
the calculation, do we have the expertise?
Not, not
Ah,
required.
We have the expertise as a judge.
Your lordship is expert, man.
No, not at all, not at all. We can understand violation of principles of natural justice and all that.
The
but
calculation is
on
also
that-
interpretation, your lordship. That I will place, man. Calculation is also as per.
Okay, right. Mr. A. Goyal, learned counsel for the petitioner,
Petitioner.
established that he will be filing affidavit in reply within 2 weeks. List the matter on, give a date. 18. Then you write.
Can
The
it be, my lord,
petitioner's-
in the
The petitioner's case is that
23rd or
there has been a tax levied on
VAT element?
the
VAT element.
VAT element by the respondent. On the other hand, the respondent's case is that there has been no tax levied on the VAT element.
Yeah. already levied that.
On the value. Huh?
Can it be, my lord, last week?
No, not last week, no. And it has been made only on the cost price of
My-
the item manufactured. It is, huh? Doesn't matter it. It
DPO.
doesn't matter.
My,
Whether
DPO.
your affidavit is there or not, will decide the matter.
My,
What have I said? Okay, that's all, that's all. That's all.
May I please, Lordship? Lordship, criminal appeal was fixed on the last date on 28th February. And thereafter it was ordered, a direction was given for preparation of paper book, and thereafter a date,
Paper
maybe-
book has been prepared.
yes, a date for hearing has.
You have been given copy.
Yes,
So everything is ready.
yes.
We can hear. It's a simple
Lordship,
matter.
today?
Yeah,
Ah, Okay, Lordship.
can start.
Lordship, actually there is an application for IA for suspension of sentence.
We can hear both together.
And Lordship, another prayer is that I have filed an application yesterday for seeking transfer of the appellant from Nagaon Central Jail, who is currently lodged in Nagaon Central Jail, to Sajiba, Manipur Central Jail, that is his native place. A direction may be given that that application may be taken along with this criminal appeal.
That we can decide later.
Okay.
That is not an issue. That's a different issue altogether. Right now, the issue is whether the trial court judgment
Yes.
can be upheld or not. So you can start. You are the counsel or you are the counsel or you have got a senior or what?
Yes, I have a senior.
Oh, okay. So yeah. Are you going to do this case or your senior is going to do
This
it?
is direction from my senior right now.
Oh, then it's good. But madam, I think that you see this case, there's a slight problem, I think. Have you read it?
Actually, no.
No, you have not read.
No paper book, no.
You see, the thing is that no paper book. Paper book.
Just now it has arrived.
Okay. You see, the issue is this. They have been convicted under 21C. The problem is what has been seized is meth.
Yes. Actually, 22C.
Where is the question of 21C coming into the picture? It appears, I don't know, this judge has purposely done it or what? I don't know, that the trial court that. Doesn't he know? Didn't he read 21C? And whether it will come under 22 or 29?
22C and read with 29 maybe because there
Ah.
are two accused person.
Ah.
Though both are convicted.
Ah.
And one of them is acquitted.
Huh?
One of them has been acquitted and two
So,
of them are convicted.
this is the conviction under 21C is completely wrong. But there's a charge made under 22C also and under 29. So,
Co-
whether, you see, when you're going, of course, we can correct what we can do as we think correct, but then prima facie, I'm of the view that maybe it should go back and take a decision whether this comes under 22C or 29. How can you, 21C is only for heroin,
Hmm.
not for methamphetamine and amphetamine. These are yaba tablets which have been seized.
Further, actually, there is a huge discrepancy in the
Those are on the merits. This is on the law point. How can the trial court make such a huge blunder? I don't know. Is it purpose blunder or not? Heroin cannot I mean, only heroin can be taken into consideration under 21C, not Yapa tablet.
Maybe taken up on some other day. Just to see.
Okay. But we just look into this, what to do with it, because prima facie, the judgment cannot
Stand.
stand. Because it could be a typographical mistake or wrong understanding. Without going into the merit, maybe we can send it back and let the trial court decide afresh with regard to the applicability of section 22C in the factor.
That's maybe taken up tomorrow.
Not tomorrow, next week.
He just got the paper book now. Actually, it was in your office, madam.
No, she just seen, man, it was provided just now. It is
Yeah, right.
paper books just beforehand.
Correct. Ms. B. Boyan, additional PP, praise for adjournment on the ground that.
No, she has a form.
No,
The
she has got the paper book.
Yes.
She has got the paper. On the, Mr. Panik has got it in June.
Yes.
He was ready to argue. But on the ground that, and she knows the case, straight away I could make her. On the ground that the paper book has been provided to her only just now in court. So, next up, Ms. Bibuya can have to make submissions with regard to whether the learned trial court could have convicted the appellant under section 21C NDPS Act, when the seizure relates to methamphetamine, though charge has been framed under section 21C slash 22 or 23.
23 is also there. Charge has
20
been paid under section.
23C slash 27 also.
Yes.
27A,
27A, 29,
27A slash 29.
21C.
21C, 23C, 27A, and 29. Charge has been kept.
So I don't know this trial court, how did, it's not even gone into the provisions of the NDPS Act. Is it purposely done? That's what it's coming to my mind. Purposely appears to have been done. This is a matter on when. Matter when.
That should be short date may be given. Short date.
Coming week I'll not be available. Let some other person.
Next week,
Next week I'll not be available. Let other, somebody will be there.
anyone, any
Anyone can
criminal
do
one,
this
any
kind of-
criminal. Huh? Huh? Then I don't know. You all are okay with it? Ms. Begum?
No, why not again? Somebody will be there, not part of it. After 16 days, after 16, I'll make a good practice for it.
Anyway,
Then after the vacation, then
19. No, why, you see, this is you've got to clear it up.
I may do the KCL also, but on principle, I don't want to do NDPS matters, my God. But I'll do. I'll really do.
What do you mean non-principal?
Yes.
Why?
Don't like to. 22 no.
22 is
Look, maybe 11.
20.
11 or 12.
12 is a holiday.
Oh, sorry. Maybe 11, Lordship.
22 is there. No, too near the petty.
Maybe
we
on
have
10th,
fixed
my
it,
God, somebody will be there with
Okay,
her.
this is the matter on 10th.
Please, your lordship.
This is a jail appeal preferred by the accused convict hearing under section 302. The brief The brief facts of the case, sort of details is that the accused was charged of assaulting his paternal, his relative, his nearby relative, with a axe on the side of the head, one blow on 19 to 2016, when the deceased has gone to the accused's house to charge his mobile. Apparently, this was a normal occurrence. One blow.
The act being there as a normal occurrence.
The X is there as a normal. The charging of the mobile phone was a normal occurrence.
Normal occurrence. So the deceased went to the house of the appellant,
The appellant here in on
the accused,
and
and
in the course of that charging the mobile phone, they consumed alcohol. They talked. There was a sudden quarrel. Apparently, the accused said that vacate my house, and thereafter assaulted him with the axe which was lying there, and he bled and died on the spot. And thereafter, the accused was said to have gone to the wife's place and said that I've finished off your husband. Then went to another villager's place and said confessed. And thereafter, he was caught by the
so
villagers.
extrajudicial confession is there.
Many extrajudicial confessions,
Many,
multiple.
multiple.
Going to the house and informing that I've done this, and thereafter villagers catching him, tying up in the courtyard and confessing before the villagers and the police that yes, he had committed the crime. So that part, my lord, that confession may not be admissible because it was done in the presence of the police.
But then there were others where he went to the wife of the.
Yes, there are
then-
two others, wife and
then-
there are two others.
Hmm.
That issue, my lord, it appears prima facie on that aspect clear because the accuser is also given only blanket denial. I am innocent. His plea is that of innocence.
So they were
No, the
drinking together,
Yes.
and the last he was seen was inside the house.
Last scene,
What is the explanation given by the appellant? That's the-
no explanation,
no
other
explanation.
blanket denial.
So under 106,
Yes,
a reference can be, it can be presumed
presumed, yes.
that the accused had something to do with.
My lord, that aspect, I'm not on that. There is one simple aspect which troubles me. And the accused has a history of mental illness. Several of the witnesses,
Accused has a history of mental illness.
several of the accused, the witnesses, they said that he had been to treatment in the Tezpur Mental Hospital several times, not just once. And
But how do we know that during that relevant time he was having some problem?
yes, my lord, that because at the time there was also another second factor is the consumption of liquor part.
Consumption of liquor is
Added-
no excuse.
No, my lord,
I think
added with the
86.
yes, added with the history of mental illness, consumption of liquor, and third part is the sudden quarrel. Because there is witnesses have stated that before assaulting the victim, he assaulted his own father and uncle with the same axe.
So you mean someone saw it?
They have it is there on record.
So
Maybe the family members have
So
said-
they saw the assault. Maybe the assault on the victim was not noticed, but the victim on the other family members were noticed.
Other family members noticed the assault being made on the accused father.
Accused father, by the
Father is-
accused.
Father and uncle. So, my lord, there is a pattern here which goes against the philosophy of mens rea or intent to commit a crime. Number one, because it appears that he has struck out at random. On one instance, one blow at random, because he also attacked his own father and his paternal uncle before assaulting
No,
them.
no, but is there any evidence to the effect that just prior to the incident,
Yes.
he was having some bout of mental illness?
No, my lord, that is not there. That lacuna has been left, but otherwise the burden is on the accused to show that he was suffering from some insanity or
Did he take that plea?
he did
That's
not
what-
take the plea. He took the plea only upon committal. That plea was taken only upon that committal.
That he was?
Upon the committal before the Learned Sessions Court,
Correct.
counsel took the plea that he was previously suffering from insanity.
Previously,
Previously, and thereafter he was also sent for examination, my lord. If judgment has also recorded.
That means he has taken the defense witness before the trial court.
He has taken the defense before trial
no,
court at the
no,
time
not
of
before
committal.
trial court. At the time of committal, he
At the
said.
time of committal.
Not at the time,
Yeah.
at the time when cognizance was taken.
No,
Nothing was.
that aspect was only there because otherwise there are
I think
multiple.
the issue is with this. maybe he had bouts of some mental illness earlier, depression, whatever. But the issue is at that relevant point of time,
At that relevant.
did he have the HANA? How are you going to prove that? If you have not taken it at the first instance, because from what yes, from your submissions, it appears that he used to have bouts of this mental illness.
Yes,
It was not a continuing mental illness. Correct.
correct.
It was he used to have off and on.
My lord, that lacuna is still there because the disclosure of what exactly is the nature of mental illness.
So is it your case now, as on this stage,
Yes.
that he's suffering from he was mentally ill at that time? You see, the court would have noticed.
The court has observed that
Yeah,
at the time of
observation.
at the time of occurrence, there was no plea that he was mentally ill.
No. Did the court make any observation that during the trial proceeding, the accused seemed to be mentally unstable?
No, my lord. That in fact, the court has sent him for a medical examination.
Has sent
he-
him?
Yes, yes.
So what is the
And
report?
this at page 47, paragraph 39, the relevant part regarding. I may I read these paragraphs. These are
Yeah.
on the issue of insanity. Keeping in mind the principles laid down by the Honorable Apex Court while analyzing the evidence on record, it appears that there is no evidence at all adduced by the defense to discharge the onus upon the defense to prove its claim that at the time of occurrence, the accused by reason of his mental ailment was incapable of knowing the act done by him. The defense plea solely rests on a statement made by PW 1, 2, 3, and 4 during the cross-examination. In their cross-examination, these prosecution witnesses have disclosed that prior to the incident, the accused was mentally ill. On several occasions, the accused had undergone treatment at Tezpur Mental Hospital. PW 7 and 8 had also reported that they have heard that the accused was suffering from mental illness, but they did not have personal knowledge in this regard. Apart from these evidence of prosecution witnesses, there is no evidence such as medical certificate or the documents relating to the treatment of the accused for his mental illness at Tezpur Mental Hospital at the time of incident have been produced in evidence by the defense. From the evidence of prosecution witnesses, also it is not clear that at the time of incident, the accused was incapable of knowing the nature of his act. On the contrary, it is found that after the incident, the accused went to the deceased house and informed his wife about the death of her husband and asked her to see his dead body lying on the courtyard of his house. It also appeared from the evidence on record that the accused was detained by the villagers by tying him up with a rope with a post so that he could not flee away. It is also found that the bloodstained axe which was used by the accused to assault the deceased was kept hidden in his house, and his father produced it, taking it out from the place where it was kept hidden by the accused. These facts clearly reflect that knowing fully well the act committed by him.
Come to 48, para 40.
Para 40. It is also found from the case record around 22/2016, the accused was produced by the police after his arrest before the learned magistrate. On that day, the accused was given assistance of State Defense Counsel by learned magistrate. Thereafter, till 31/5/2016, accused was produced before the learned subdivision judicial magistrate Udalguri from judicial custody in several dates. But during that period, neither the accused, his engaged counsel, nor the jail authorities submitted before the subdivision judicial magistrate that the accused was suffering from mental ailment. In the instant case, only after committal of the case, when the case came up for trial on 13/6/2016, learned legal aid counsel submitted before the court that perhaps accused was suffering from mental ailment. Thereafter, the accused was examined by a psychiatrist, and later on the basis of the report, doctor was admitted to the Lokapur Governor Bodloy Regional Institute of Mental Health, Tezpur, where he took treatment till 5 May 2017. After 1 year. After 5 May 2017, on the basis of the report of psychiatrist that the accused had recovered from his illness and he was fit to be discharged, trial of the instant case started from 19 May 2017. On 30 October 2017, again, the court issued order calling for a report from the Lokapur Governor Bodloy Regional Institute of Mental Health, Tezpur, regarding fitness of the accused to stand trial.
He was fit.
Well, that I do not have the report. If the report discloses what is the nature of the mental,
Are you doubting
my lord,
the
I do not-
observation made by the court?
my lord, because there is 1 year of treatment, continuous treatment. That is the only thing which is troubling.
He has been certified
Certified
twice
twice.
that he is fit.
Other than that is of course the facts are covered by the extrajudicial confession made before the wife and as well as the informant.
So he's been sentenced to life,
He has been sentenced to life.
and that was the year.
That was as on date. This is 2008, 19, 2019. The total custody is around almost 9 years.
So after 14 years, he might have a chance for remission.
My lord, that is There is no observation that without parole. So there is a chance. Considering his age and
How old is he?
at the time of commission of offense, he was 24.
Yes, madam.
He was admitted in the LCBI Medical Hospital, my lord. Was treated there, your lordship.
Treated in which year?
Yes, it was, lordship, there's a order dated 11/7/16 of the trial court. Accused Mohesh Kosar is produced from custody. He is remanded to custody till 25/7/16. Superintendent District Jail Udalguri, in compliance of this court's order dated 27/6/16, forwarded medical report of the said UTP medical and health officer. One, Udalguri Civil Hospital opined that the UTP Mohesh Kosari has been suffering from general weakness. On being asked some questions, said UTP could not give any rational reply. He appears to be unmindful and exhibited behavior which appears to be not normal. Learned Defense Counsel submitted as such behavior of the UTP is not normal and the UTP is unable to make proper defense with his present mental health. Learned additional PP Mr. B.K. Chetri submitted that UTP Mohesh Kosari needs to be thoroughly examined. Taking into account the behavior conduct of the UTP, I am of the opinion that he needs proper medical examination to ascertain his mental health by a competent doctor. Superintendent of District.
No, madam, you see,
My lord.
those are neither here nor.
No, then thereafter there are orders.
Ah.
His mental lordship health status was examined by a doctor.
That was
So,
considered.
Yes.
what are the final results?
That was considered.
So what is your case? That he was not mentally stable? Is that your case?
Lordship, I have not, because I don't have the paperwork from the order sheet.
This is-
Lordship, I'm not making the
Uh,
submission, ready the case.
You see, the very purpose of listing a case is to enable the court and the lawyers to be ready.
Always your
Every
lordship.
day,
my
every
lord,
day,
need to
we
make
have
my
to read
lord.
new cases out. It is not that I know tomorrow what cases are coming. I don't have a chance to read tomorrow's cases now. I have a chance to read them only at night. So that excuse that
I'm not making any excuse, whatever is on record, because it's our office which provides us with the copy of the paperwork.
Correct.
Today, they have not, and I am not seeking for any adjournment, my lord. I'm going through the records.
I am asking
Making a
you,
submission.
Adam, I'm asking you this
My lord.
question. Whether your case is that the appellant was
Suffering
mentally
from-
unstable at the relevant point
Yes,
of time.
ma'am.
So what is the final and what is your argument going to be? Is it for him or against him?
Because I'm going through the record just now, when your lordship takes up the matter, okay, I'm going through the records, my lord. Lordship, there are orders, my lord. It judgment to be dismissed.
2019, 24 July 2000.
State of mind. Yeah.
The judgment mentions during the trial, he had undergone medical treatment, but subsequently he had recovered from his ailment. So when subsequently he had recovered, that we require.
No, the issue is this. Now, at today, can we come to a finding that he was mentally unstable at the time the incident occurred?
My lord, that finding, not at that, not as on date, not by the.
Can
FS
we
that-
do it today?
No, my lord.
Then?
But my lord, during that trial, was he fit to stand trial at what
Well,
date?
that is now what has the trial court held?
That is the finding. we-
It has found that he was fit to stand trial.
But on what date, my lord? That is the finding that was going, because they're saying during the
No,
trial.
no, man, Mr. Counsel, please read. You have also not read.
On
Okay,
five,
I understand,
on 5
but you
days.
see out here, at page 48, para 40, it says here, the court issued order calling for a report from the LGPR Institute of Mental Health Test Group regarding so and so. Test court submitted the report. Accused was fit to stand trial. Since then, the trial of the instant case proceeded without any incident.
May I know the date, madam? Date?
This is the judgment and order. Para 40.
On 30/10/2000.
Whatever it is, the trial started when the court came to a finding that he was fit to stand trial. And that finding has been made on the basis of the report made by the Tezpur Mental Hospital.
Well, that order would be there that
Lordship,
trial
there's
to
a order
commence.
5517
Yes.
of the trial court.
Yes.
LZB Regional Institute of Mental Health has to submit a medical report of UTP Mahesh Kasari on 12/4/17. I have perused the same. From the report of the LZB Regional Institute of Mental Health, it appears he is currently fit to discharge. Superintendent of District Jail Udalgur is directed to do the needful production of the accused before the court. Fixed 19/5/17 for production of the accused.
Then it says on 30/10/17, again court issued order calling for report submitted. He's fit. Now that aspect as to whether he was sane while the proceedings were going on has already been answered by this para 40.
Mr. Counsel, you need to convince us that in fact, he was going through mental illness. From the evidence or whatever materials before you, so you'll have to convince us that it was wrongly held by the trial court.
Well, from the evidence which I have read, Malot, as on date,
Evidence you have not read.
Malot,
you need to
just
mention that there are some statements regarding that.
yes, my lord, that may I read the evidences, my lord, if from the beginning, my lord, because there are first thing, there is a material contradiction on the aspect of the X being kept hidden. That has been a significant fact relied on by the learned trial court to infer that there was an intentional act on the part of the accused to commit a crime and then hide the fact that he had committed a crime.
So the axe was not found.
The X was finding, all the witnesses stated the X was lying on the side of the dead body. It was not hidden. Two witnesses later on who signed the seizure memo, they said that the X was produced by the father from inside the house where it was kept hidden. It produced the X. And another witness says
Father of the accused.
And the family member says another family members produced the X from inside the house. But all the other 7 witnesses, they say the X was lying on the side of the body, bloodstained X lying on the side of the body, which was also bleeding out at that point in time.
So what are you trying to say?
My lord, that it was not kept hidden. That there is a reasonable inference to be drawn that it was not kept hidden by the accused.
Okay, if it was not kept hidden by the accused, then what is the consequence of that?
My lord, that implies again that there was not a conscious decision by the accused to hide the fact that he had committed a crime, or that therefore he may not have been knowing that he had committed a crime by reason of his unmindfulness or his temporary insanity. He may have hit the person with the X, but hiding the X is a further step forward in the act of commission of a crime. It implies conscious knowledge.
There are many cases where a person has committed a crime and has approached the police station voluntarily, unilaterally. Doesn't have to be that someone has to run away or hide or pretend that he did not do it. Sometimes they admit. And
There's an order that he is fit to stand the trial.
correct.
Dated 5/12/2017. Like perhaps like.
No, you see, we are not on that now. Because the trial took place there when he was sane. That is clear. The only issue is whether he was mentally unstable at the time the incident occurred. Unless you show some material to show that he was having some illness at that time, How do we go into that aspect now?
Well, that is also my difficulty because unless I know what exactly the illness is as per the diagnosis, it is difficult for me to convince your lordships whether it is a temporary or a recurring or a permanent disability. Because there are different.
No medical certificate was released.
Yes.
Nothing, no
No.
material on, as far as the medical record is concerned.
Yes. There is no medical certificate. There is no, I will only be presuming if I were to say that this is a recurring illness or a, at that time it was there, now it has disappeared. That would be a presumption. There is no evidence as.
There are extrajudicial confession, my lord, which is, I think, lordship, sufficient in the present case to uphold the conviction, my lord. Vis-a-vis the injury received by the accused, the deceased, my lord. It was on a vital part of the body, my lord, and he died instantaneously.
He died of brain injury.
Yes. I think all the steps have been taken by the learned trial court, lordship. As regards provision as to accused person or unsoundness of mind, section 328 onwards, your lordship, of the CRPC.
If I may be permitted, my lord, to read an extract of a case law, my lord. This is 2011 SCC.
Yeah.
495, Surendra Mishra versus State of Jharkhand.
2011,
11 SCC 495.
11.
11 SCC 495, Surendra Mishra versus State of Jharkhand.
Yeah.
Although this is from a reference textbook, so it will not be exact, but I'll just read the gist of it. In law, the presumption is that every person is sane to the extent that he knows the natural consequences of his act. The burden of proof in the face of Section 105 of the Evidence Act is on the accused. The burden is on, though the burden is on the accused, but he is not required to prove the same beyond all reasonable doubt, merely satisfy the preponderance of probabilities. Onus has to be discharged by producing evidence as to the conduct of the accused prior to his offense, his conduct at the time, or immediately after the offense with reference to his medical condition by production of a medical evidence and other relevant factors. That what is there. Even if the accused establishes unsoundness of mind, Section 84 of the IPC will not come to his rescue in case it is found that the accused knew what he was doing was wrong or that it was contrary to law. In order to ascertain that, it is imperative to take into consideration the circumstances and behavior preceding, attending, and following the crime. Behavior of an accused pertaining to a desire for concealment of the weapon of offense and conduct to avoid detection of a crime go a long way to ascertain as to whether he knew the consequences of the act done by him. But that is the point I was making. So lack of pre-planning, consumption of alcohol, history of mental illness, undefined mental illness, sudden quarrel, a blow struck by an ex, only one blow as per the witnesses, which immediately led to the death. These all go towards mitigating the gravity of the offense and perhaps raising the presumption that accused may not have intended to kill or may not have intended to inflict a blow sufficient to kill and may not even have known the consequences of his act
But
by
usually-
refusing
Usually, would
consequence.
a normal person drink with a mentally unstable person?
That is also. We have no idea. of
I
that.
wonder what type of conversation you'd be having.
That is
Very
also-
interesting it would be.
and immediately going to charge the mobile phone and starting drinking.
Yeah.
Maybe he was also not aware. This was a long-standing practice.
No, but you see, if a person is a friend or an acquaintance who you have known for a long time and you have been drinking with him a long time, once he becomes ill, mentally ill,
Hmm.
I don't think you'll be treating him as a sound person. You'll be looking, you as a friend, you'll be thinking of his health. I mean, at least a normal person would.
Hmm.
You won't say, okay, yeah, you're mentally unsound. Okay, come, we'll have a drink. I doubt you'll do that. What kind of conversation would you have? You'll talk about what? Politics? Difficult. Yeah. And where did the axe come from?
The X has not been X is not even it is not even mentioned as being a weapon kept by the family because usually it is a dao. The usual weapon is a dao kept in the
Ah,
household.
no, but they've said axe, is it?
They have said X 2.5 feet long with a wooden handle.
The villages, that is the
2.5
5
feet.
feet long with a wooden handle.
Axe.
An axe.
Axe is not 2.5 feet long.
My lord, that is-
When it be? With the handle. Okay, with the handle.
with the
it is
handle.
2.5.
With the hand. Handle is 2.5 feet.
The handle is 2.5 feet.
Well, I've read it somewhere. I'll just point it out. The seizure memo would indicate the page 59.
Okay. So PW4 is the wife of the deceased,
Yes.
to whom he informed that he had killed her husband.
No, my lord, that is PW2 is the nephew. He is the informant. He is the nephew.
Okay.
He has also,
No. PW4 is the wife.
yes, my lord, the wife is not the informant.
I know, but
But
I'm
He
saying
was
that
also informed to her.
She has-
the accused informed the wife.
yes, and also informed the informant also. He went to his house of the informant also.
Informant is PW.
Two.
Two.
PW2, page 9.
While I was at my house, the accused came to my confessed that he had killed Raju. There is nothing to show that he was mentally ill.
Hmm.
Before killing my husband.
and nothing came out from 313 also.
No.
He didn't say, he didn't utter a word about his.
He didn't utter. He simply said, I'm innocent without explanation. Anything.
So, what according to you comes out from the evidence that has been accrued?
My lord,
Is
according
it,
to
does
the-
it support the appellate?
it supports the commission of the actual act that took place That is beyond doubt. There is no other explanation. There is no other person on the scene. And there are,
And it is clear that he is the one.
it is clear. It is
It is clear that he is the one. Only thing is there anything to show that he was mentally unstable at that time?
at that time there is lacking.
That is not
only-
clear from it.
I'm only relying on the antecedent behavior and the aftermath, the behavior of the accused. But in support of that, I am possibly would need a medical certificate as well.
There was no medical certificate prior to the incident.
There was no medical certificate at all. The fact of insanity has only come out from the evidence testimony of the prosecution witnesses who said that several times he had gone to the hospital, Tezpur mental hospital.
That is also only in the court, not in their main examination.
Yes,
That has been a suggestion put.
suggestion.
Yes, madam.
Lordship, all the procedures have been followed by the learned trial court. As regards unsoundness, my lord, then when he was fit to, when he, the magistrate considered he was fit to stand the trial, then only proceeded with the case, my lord. Proceeded the trial. And learned, this one, my lord, the accused did not take any plea. It you want you also that he was suffering from mental illness. And during, while he was, the charge was framed, he's denied the charge and claimed to
No
withdraw.
family member has also come as a defense witness to show that he is suffering from
Right.
mental illness, though he was living with his parents.
He was living with his parents. He was living in his father's house. This was his father's house, not his house. And
How do we, how do we come to a different conclusion than what has been decided by the learned trial?
my lord, evidence is slightly
Yes,
underwhelming.
because if the family had at least come out and said that, yes, he is suffering from mental illness, there's nothing. And that is his own, his parents were living with him.
His parents, they also did not appoint any
It's
counsel.
always very difficult to prove whether at that point of time he was suffering from the illness or not. But you'll have to gather for like
This is-
previous instance and like later on incident. And I think there are many pronouncements of that.
The law is clear in that sometimes it is basically on whether that certificate would cover that period of time of commission of offense or not. Yet here there is no certificate.
No, besides that, his parents could have,
Given
adduced
testimony.
evidence.
It is evidence. Yes.
Parents could have, neighbors could have done that. His relatives, his cousin brothers or cousin sisters, somebody could have come and acted as a defense witness.
Yes.
Or the doctor who had treated him earlier. You could have, at least he could have given a list of witnesses and asked for them to be called as a court witness. No one has been called. Right. Heard Mr.
Enborough.
and Barwa, Senate counsel for this petition. I appellate. Also heard Ms. B. Boyan, petitioner B. This appeal has been filed against the judgment dated 24/7/2019, passed by the additional session judge Udalguri in section case number 53/2015, by which the appellant has been convicted under section 302 IP and sentenced to undergo rigorous, and sentenced to undergo life imprisonment with a fine of rupees 10,000, in default, rigorous imprisonment for 6. The prosecution case in brief is that an FIR dated 20/02/2016 was submitted by the nephew of the
Deceased.
deceased, PW2, to the effect that at 5:30 p.m. on 19/2/2000. The deceased had got no, the appellant. No, no, he's the
It is the deceased.
he's the okay, deceased, nephew of the deceased.
Nephew of the deceased.
Acha. Oh, the you as what have I said? Last sentence? Uh, the deceased had gone to the house of the appellant to charge his mobile phone. However, a quarrel broke out between them, due to which the appellant struck the head of the deceased with an axe. So, pursuant to the FIR dated 20/02/2000, Hari Singha PS case number 12/16 under section 302 IPC was registered. So, the investigation was thereafter conducted by the police, and the same led to a charge sheet being filed against the appellant, comma, on a prima facie case being found against the appellant under section 302 IPC. Next. The learned trial court thereafter framed a charge under section 302 IPC against the appellant, comma, to which the appellant pleaded not guilty and claimed to be correct. The learned trial court thereafter examined 10 prosecution witnesses, and after having examined the appellant under section 316 CRP, it came to a finding that the appellant was guilty of committing an offense under section 302 IPC. The appellant was accordingly sentenced under section 302 IPC by the learned trial. Next one. The learned, Aaron, am I just or what?
Yes, madam.
The learned amicus curiae submit that during the cross-examination of the prosecution witness, it had come to light that the appellant had undergone medical treatment for mental illness. He submits that besides the issue of mental illness of the appellant, the appellant and the respondent and the deceased had been having drinks prior to the assault on the deceased by the The drinking of alcohol would have exacerbated the mental illness of the appellant, which led to which apparently led to the assault being made on the deceased. He submits that as the as there was a history of the appellant having mental illness, suffering from mental illness. The appellant could not have been convicted under section 302 IPC. No, CRPC, IPC. In terms of section 84 IPC. Correct. That's all.
And also the subsequent behavior of the accused, wherein the murder weapon was not kept hidden but was lying in full view, as well as no noticeable attempt to run away.
Stop. The learned next para, the learned amicus curiae submits that the fact that the murder weapon, that is the act, was seen lying next to the deceased, and the fact that there had been no attempt by the appellant to run away would imply that the appellant was not in his full senses at the time the incident occurred. He accordingly submits that keeping in view the history of the mental history of the appellant, the the alleged act of the appellant in killing the deceased would not be said to be an offense due to the appellant being of an unsound mind. The appellant, due to the appellant suffering from unsoundness of mind. That's all.
That and the case law which I have noted, that is reiterated, that substantially reiterated as well as in the judgment, page 41. 2007 8 SCC 66, the paragraph, which states that the burden of proof to prove insanity is that akin to that of a civil proceeding. Preponderance of probabilities. So it can
This
be.
is 2007.
This is 2007. The same principle has been reiterated, that it is not so onerous as beyond reasonable doubt. If there is at page 42, in dealing with cases involving defense of insanity, distinction must be made between cases in which insanity is more or less proved. Question is only as to degree of irresponsibility, and in cases where insanity is sought to be proved in respect of person who for all intents and purposes appears sane. In all cases where previous insanity is proved or admitted, certain considerations have to be borne in mind. Whether there was deliberation and preparation for the act done in a manner which showed a desire to concealment, whether after the crime offender showed consciousness of guilt and made efforts to avoid detection, whether after his arrest he offered false excuses and made false statements. All facts of this sort of material as bearing on the test submitted to jury. Would the prisoner have committed the act if there had been a policeman at his elbow? So these are the attending
You see,
circumstantial
but
facts.
how do you show that after the act was committed?
Yeah.
His behavior showed that he was not in control of his senses.
Because at the time when he was, even before the trial court, when he was asked, there was no excuse. There was no false statement. He said simply blanket, I am innocent, which is a childlike way of
That is,
saying.
no, that is a blanket denial. Blanket denial, the Supreme Court has said that when there is a blanket denial
Yes.
and there's no attempt to make to explain the evidence against the person,
Mm.
then the court can presume, can make a presumption against the accused.
And again, the desire for concealment wearing the hidden X question comes in. No, there is no desire for
So
concealment.
when the question of you see, sometimes people are filled with remorse for what they have done. So they don't want to hide. If it can be said that normally people will hide their weapon and everything, but that is not the case in every case, only in few cases. If you can show that that is the rule, that is okay. That usually people hide and everything.
Hmm.
But
That is not.
In the bottom line, that paragraph we have read
Yes.
out. Bottom line, if it is without the bottom line, these states are not always reliable, but there is
Inferential. That is an inference.
exposed.
At, at this point, we are inference.
okay, right. The learned counsel thus submits that in cases involving a defense of insanity, and where insanity has been proved, comma, the question would revolve around the degree of irresponsibility. In this respect, he has relied upon the judgment of the Supreme Court in the case of 2011 11 SC 3495. Correct?
Right.
Next up. Between P. Booyah, the additional PP, on the other hand, submit that the plea of insanity had never been taken by the appellant during the trial proceeding. In fact, the issue of whether the appellant was of unsound mind had only come up at the time of cross-examining of the prosecution witness. He submits that when there has been no plea taken by the appellant during trial, that the appellant was of an unsound mind, the said question would not be raised in the appellate state. What is it?
Lordship, I want to read out my submission.
Ah,
Learned trial court took all the possible steps while those plea was taken, but it has come to
You
the
also
notice of the trial court.
he also submits that the issue of insanity was taken up by the learned trial court. And
Early dealt with.
a report had been called for from the concerned, from the concerned mental hospital. From the concerned, Thereafter,
Please,
when the
last one, Warren.
Lokopriya Gopinath Bodoloy Regional Institute of Mental Health, test submitted its report that the appellant was fit to stand trial, then only the trial court started the criminal proceedings against the appellant.
That is a report of the LTB. One more plea, I'll take your
What
lot.
is this judgment?
105 burden. Once the plea is taken, the burden is on the accused to prove. Para 15, my lord, para 15.
Para 17 you mean?
Para 15, there are sub-paras, my lord. After adverting to section 84 and 229 of the Indian Penal Code.
Which
Oh,
judgment?
oh, Mariappan, my lord. He has given,
Para 17.
oh, I'm reading from Manupatra, your lord.
Then
My lord.
Manupatra is different.
After adverting to sections 84 and 299 Indian Penal Code and section 105 and 101 of the Evidence Act, this court concluded that when a person is bound to prove
After 14, after 14.
It's 21.
Para 21,
21. After
Ah,
13,
that is a para 21.
my lord. Lordship, then one paragraph has been quoted. It is also a settled proposition of law that a crucial point of time for ascertaining the existence of circumstances bringing the case within a purview of section 84 is time when the offense is committed. We may notice here the observations made by this court in Ratan Lal versus State of MP in para 2 of the aforesaid judgment. It is
This is correct. That's what we have been saying all along. At the time of the incident.
my
What I said, he also submit that the appellant would have to establish that at the crucial point of time when the incident occurred, the appellant was of an unfound. However, no such evidence has been produced by the appellant. Even though in terms of section 105 of the Evidence Act, a person is bound to prove the existence of any fact. No, no. When a person is bound to prove the existence of any fact, the burden of proof lies on that person. Okay. That's all. Accordingly, submit that when a parent has not been able to provide any evidence to show that he was mentally unsound on the date of the incident. There was no informant with the conviction of the appellant by the learned trial, especially when the appellant had given his extrajudicial confession to PW 2 and 4. We have heard the learned counsel for the a perusal of the record and the submissions made by the counsel for the party show that the deceased had gone to the house of the appellant to recharge his mobile phone. The deceased and the appellant thereafter sat down and started drinking liquor. While drinking liquor, an argument ensued between them. An argument ensued between them. So thereafter, the appellant apparently hit the deceased on the head with an axe, which resulted in the appellant succumbing to his injury. The axe that had been used, no, next para. The appellant thereafter went to the house of PW2 and informed him that and confessed that he had killed and confessed to him that he had killed the deceased. The appellant also went to the house of the wife of the deceased and informed her that he had killed her husband. The PW two and four thereafter had gone to the house of the appellant and saw the dead body of the deceased. The evidence of the cross examination of PW4 is to the effect that before killing her husband, the appellant had assaulted his own father and uncle with a dove, but they had survived. The evidence of PW six is to the effect that on hearing a hue and cry, he had come out from his house and rushed towards the place of occurrence. Thereafter, he went to the house of the appellant, where he saw many people had gathered there. He saw the dead body of the deceased on the ground in a pool of blood, and his head had been cracked open. The appellant had been detained by the local people in his house and had tied his hands. PW6 further stated that the appellant had confessed before him and the police that he had caused the death of the deceased by hitting him on his head with an axe. PW6 further stated that the father of the appellant produced the axe before the police, stained with blood. The evidence of PW7 is similar to the evidence given by PW6. However, PW7 stated that the family members of the appellant had produced the act, but was hidden inside the house, and the act was stained with blood. The evidence of PW8 is to the effect that the villagers had informed him that the appellant had killed the deceased. And on the side of the deceased, and when he went to the house of the appellant, he saw the dead body of the deceased. On the side of the dead body of the deceased, a blood-stained axe was lying. When the police came to the house, the father of the appellant told them that the appellant had killed the deceased by means of an axe and pointed to the blood-stained axe lying by the side of the deceased. The evidence of PW9 is to the effect that he had been told by the village people that the appellant had killed the deceased, and he had seen the dead body of the deceased with a cut injury on his neck. The evidence of PW10, who is the IO, is to the effect that he was informed over phone by the OC of the Paneri police station that a murder had taken place, which he was asked to investigate. On reaching the place of occurrence, they found the dead body of the deceased with injuries on his head, and the axe was also lying by the side of the dead body. The appellant had been apprehended by the village people and had been confined by them in his courtyard. The dead body was then taken to the Harisinga PS along with the appellant. The FIR was thereafter lodged on the next day, and he thereafter submitted a charge sheet after completing his investigation. He also PW10 further stated that he did not send the seized act for FSL examination. Next part. The examination of the appellant under section 316 CRP shows that the appellant had made a blanket denial with regard to all the evidence that had been adduced against it by simply stating that he was innocent. On the question of sentencing the appellant, after having been found guilty under section 302 IPC by the learned trial court, the appellant had pleaded for mercy and prayed for being given a lesser punishment. Next part. The facts of the case as enumerated above clearly show that the last seen theory would be relatable to the fact of the case, and that as the incident had occurred in the confines of the four walls of a house, the appellant would be in the best position to give an explanation as to what had happened leading to the death of the deceased. However, the appellant has not discharged his burden in terms of section 106 of the Evidence Act. A perusal of the record shows that no plea of insanity had been taken at any time prior to filing of the charge sheet by the appellant. As such, no, though the question of insanity cropped up during the committal proceedings, during the time of committal of the case to the learned sessions court, and in the cross-examination of the prosecution witness, the appellant had been found to be mentally sound in terms of the reports issued by the Loco Priya Gopinath Bordoloi Regional Institute of Mental Health, test, which had stated that the appellant was fit to stand trial. It was only thereafter that the appellant was, it was only thereafter that the criminal proceeding was allowed to continue. The above being said, the issue pertains to whether the appellant was of unsound mind at the time of the incident occurred to enable him to get the benefit of section 84 IPC. Section 84, Section 84 IPC and Section 105 of the Evidence Act 1872 states as follows. In the case of Sudhakaran versus State of Kerala, 2010, 10 SCC 58. The Supreme Court has held that when a person is bound to prove the existence of any fact, comma, the burden of proof lies on that person. It further held that the crucial point of time for ascertaining the existence of circumstances bringing the case within the purview of Section 84 IPC is the time when the offense is committed. Full stop. Thus, the crucial point of time at which unsoundness of mind should be established is the time when the crime is actually committed. And the burden of proving this fact lies on the person claiming to be a unsound man. In the present case, no plea of insanity has been taken by the appellant at any time during the investigation. The plea of insanity has not been taken even by the parents of the appellant at any point of time, even though the appellant was living with his parents. The question of whether the appellant was of unsound mind could also have been noticed by the IO, witnesses and villagers, including family members, and family members, with regard to the proximity of the said mental illness and the act of killing the deceased. The same was never an issue at any point of time during the investigation period. And as such, it cannot now be decided and it cannot be now determined as to whether the appellant was of an unsound mind at the time the incident occurred. Full stop. In the case of so reported in 2011, 11 SCC 495, the Supreme Court has held at which paragraph?
My lord, the paragraph is not mentioned there.
Not mentioned. Okay, you have given me homework.
My lord,
how
when-
long is the judgment? 2011,
Mishra.
11 SEC.
Well, the size submissions are recorded in page 40 in the
I
judgment
don't
itself.
know whether that is there or there.
2011, 11 SCC 495. Surendra Mishra versus State of Jharkhand. The legal principles are reiterated in the judgment itself. At page,
Let me see the thing. Sometimes there are some changes made by the authors of commentaries. Print out.
yes, this judgment also notes the Bapu Gujarat Singh versus State of Rajasthan, page 42. It has cited that paragraph 7. The judgment relied on by the trial court at page 41. It also mentions this.
Which paragraph was retired?
This paragraph in by the trial court,
He has quoted one paragraph.
yes, the 2007 8 SCC 66, Bapu alias Gujarat Singh versus State of Rajasthan at paragraph 7 as per Manu Patra citation. This is there in the judgment at paragraph 32.
No, in this has been paragraph 11 was quoted. This
It's,
trial court.
it's
Okay.
the same judgment has been quoted.
Into this. Yep.
That's correct. In the case of, the case of Kaprana, 2011, the Supreme Court has held that an accused who seeks exoneration from liability of an act under section 84 of the Penal Code is to prove legal insanity and not medical insanity. Expression, inverted commas, unsoundness of mind, inverted commas, close, has not been defined in the Penal Code, and it has mainly been treated as equivalent to insanity. But the term insanity carries different meaning in different contexts and describes varying degrees of mental disorder. Every person who is suffering from mental disease is not ipso facto exempted from criminal liability. The mere fact that the accused is conceded transfer, the para 11, take it up, not para. Next. The Supreme Court in the above case of Surendra Mishra Supra has further held that though an accused may suffer from certain mental instability even before and after the incident, full stop, no comma, one cannot infer on a balance of preponderance of probability that the accused at the time of commission of the offense did not know the nature of his act, or that it was either wrong or contrary to law. Full stop. Next para. On considering the law laid down by the Supreme Court, as quoted above, as indicated above, and keeping in view the fact that the appellant, his family, villagers, etc., had not taken any plea that the appellant was incapable of knowing the nature of his act, which would attract Section 84 IPC, we are of the view that the plea of the appellant being of unsound mind is not attracted to the facts of this case, especially when there is nothing to relate. There is nothing to relate the appellant. There is nothing to relate the fact that the appellant used to off and on suffer from mental instability. And which was also present at the time of the commission of the act. For the reasons stated above, we do not find any grounds to interfere with the impugned judgment and order, with the impugned judgment passed by the learned trial. The appeal is accordingly dismissed. Here, am I correct? Then you write, send back the PCR. And next para, you write, in the appreciation of the assistance provided by the learned amicus jurist, the fees of the amicus jurist shall be paid by the Assam State Legal Service Authority.
Okay.
Lordship. Can the item 13 be taken earlier, Lordship? Item number 13.
13, you're ready? You're 13.
No,
No,
no.
madam. I'm 10.
That date,
Right?
I'm not feeling well, Lordship.
So
So
why do you want 13 then?
then, Lordship, after completing, I can go, Lordship. I'm not,
We can do 10, he's ready. Oh, you're not ready?
I'm ready for 13, Lordship.
Series matter.
Series matter, because
Oh,
He's not keeping well, she's
you're not keeping well and you want to do the series matter.
Lordship, because already fixed, so I thought.
Okay, then he's not feeling well, what to do?
Well,
No, that,
Not feeling well and I'm prepared for this. matter.
madam.
No, 10, I'm ready with 10.
Oh, you're ready?
Yes. since
Okay,
it's
you want
not
to do
feeling well,
13 first.
Yes.
We'll do 13 first, then we'll do yours.
Madam.
Because she wants to be accommodated
Madam.
due to her illness.
Lord,
Acha, it is item 30. Thank you.
Lord. 13.
Acha, it is that matter.
That matter, the query, Lordship, that nobody have seen whether the
Okay, that girlfriend business.
lordship, lord-
My lord Justice Kalita may have to apply.
We just try, let us see. Let us see, we just- Yes. So the query was
lordship,
whether there were any eyewitnesses to the killing of the deceased.
lordship. There were no eyewitness to see the accurate time where how he was killed. But lordship, from PW's 1, 2, 3, 4, 5, they're consistent, lordship, that the accused was confined, lord. Confined by the accused person, and moreover, lordship, there was the accused came and assaulted him without any reason. There was no animosity between the accused and the deceased, lord. And another aspect is that, lordship, PW6, he was the brother-in-law of the accused, deceased. The deceased have rang him regarding the money. That is of the severe, lordship, that at the time of when he called the deceased,
We won't finish before lunch.
that will not be finished, lord. And the medical, lordship, 36 hours, goes with the evidence that
Anyway,
there,
what to do? I don't think we'll finish before lunch. It has to go after lunch.
lord,
After
Yeah.
actually it's for that only yesterday also I went home, lordship. Today, as lordship has fixed the matter, so I don't want to take any adjournment. So I was there, but I am fever, lordship, viral.
it's all right.
But no problem,
He's having a fever.
No. I can't object to that.
because
I can't object.
Okay, right. Miss Abeka prays for a gentleman on the ground that he is not feeling well. This is the matter on
Seven,
any day, next week, any day,
eight.
lordship.
Next week, my lord, 8.
দিচ্ছে আপনি ব্যবহার মাত্র কত 15 তাহলে তোমার রাত্রিটা পাকলে I was 15 Okay, আরে কত পাইতে হবে আজকে কল কম এটা আরাম করাই
Nine.
9. 9.
Because we could have done it after that, but since he said that he's not feeling well.
I'm not. I can't object on that ground. I think if you can.
That's nothing, then till 3 o'clock I'll manage, lot.
No. We don't want you to. We want you to come tomorrow also. Then you will say that force me to
No,
stay
no,
out
no, no,
all the
no.
time.
Let her take little bit rest
Ah.
so that with my lord
But lordship,
force my lord she can
prepared.
argue the matter online.
Prepared, lordship.
Oh, very good.
I have gone through how to
You go home with that and you prepare some more for this.
lordship.
This is what?
Well, this is one allegation against the husband, my lord. Killed his wife.
Here I have got two paper books.
Oh, you got two. Any eyewitness?
Daughter is the eyewitness.
Daughter's eyewitness.
Daughter. Well,
Yes.
she was minor at that time.
Huh?
She was minor at that time.
How old?
At that time, she was 16.
Oh, 16 is 16.
And my lord,
Very
And-
difficult.
other my lord, brother and sister, there are two more children, my lord, brother and sister. All were present, but those two were not examined.
How does it matter? One is enough.
And my lord,
Why is it your case that the 16-year-old is a liar?
no,
Total
I
liar?
cannot say, my lord, I can because because
if-
while she was examined, my lord,
Uh-huh.
deposed her evidence before the court, then she attained the age of 21 years.
Maybe, you see, the thing is that, you see, you've got to imagine asking your children
My lord.
to give evidence of this nature. Or you're going to put them through so much trauma. Imagine them going to give evidence as to whether the father killed the mother. That is pure torture. I mean,
But that is true, my lord.
that too-
Very unfortunate even.
So one is enough, unless it is your case that the daughter is totally unreliable person, not worthy to be a witness.
My lord, that is what I am
Is that your case?
trying to submit, my lord.
Okay, so that is your case.
Yes, my lord, because my lord, there are some evidence, my lord, there are some material, my lord, contradiction, which are, my lord, not, my lord,
Which go to the root of the matter.
yes, my lord.
Does it go to the root of the matter?
I think so, my lord. Because, my lord, there is some contradiction she has not stated before the, my lord, police
What,
during
what is
evidence.
she going to gain out of telling a lie?
Against his father.
No, let us ask. I think,
My lord,
what will she gain?
that
Has she got
she
any,
even lose, my lord. I
has she
can,
got any personal enmity with you?
that is not established, my lord.
2 o'clock, madam?
Well,
Was,
My lord,
this,
my lord, may I pay, my lord? Instead of 2, my lord, because I have one fixed matter at 2, my lord. After 2, my lord.
now, she will start off,
Yes, sir.
then because, no, you start, madam, you start
Madam.
at 2, and as soon as he comes, he'll start, because basically the issue is whether the daughter is a reliable witness.
This
That's
one.
all. There's nothing else. You've got you've got Mount Everest in front of you. It
My lord,
appears.
that is, my lord.
A hard climb. 2 o'clock.
But item number 12, I am for the respondent, they are the appellant, madam. Matrimonial dispute, talk of compromise is going on between the parties, so it may be taken up after puja.
Talk of compromise going on where? Amongst yourself?
Yes,
Why don't you go to the
mediation
mediation?
fails.
Oh.
Then thereafter, with the instance of the council of both the parties.
Right. The council for the parties pray for adjournment on the ground that settlement talks are ongoing between the parties, comma, though the mediation effort had failed. List the matter on
Immediately after puja.
after the. I'll give a date.
the prosecution story in brief, here's the lordship. FI is at Peace Court. FI is lost by Sadananda Dekka, my lord.
Who is she? Who is he?
He is PW2, my lord. He is the brother-in-law of the accused person.
Brother-in-law.
Accused person, my lord.
So the brother of the wife.
Yes. Page 4 is the FIR. Humble submission is that around 3:45 p.m. today, that is on 1/6/13, the above mentioned accused, that is the husband of my younger sister, Leela Thakuria, killed my said younger sister by hacking her with an axe inside the house. I therefore pray to you to take necessary action upon investigation into the matter. Then thereafter, charge was framed, your lordship, at page 6. It was framed under section 302 of the Indian Penal Code at page 6, your lordship. Your prosecution examined, my lord, 10 witnesses, wherein PW1 is a lordship, is a Caesar witness. PW2 is the informant, who is the brother-in-law. PW3 is a Caesar witness, my lord.
Just a
And
minute.
my lord,
PW1 is the
Caesar witness. And your lordship may take it, his version as a res geste, your lordship, because prior to the occurrence, he was there. He was riding the motorcycle.
okay. Then
Then PW2 is the informant and brother-in-law of the accused person.
uh,
PW3 is a Caesar witness, Noresor Decca.
He's a witness.
Yes, my lord. PW4, he's the lad Gaubura. Ramesh Burman.
PW5,
PW5, my lord. Just acquaintance, my lord.
acquainted.
Yes.
So
I
not,
know that.
not an eyewitness.
No. 6 is the Caesar witness. 6 and 7 are the Caesar witnesses.
He's a witness of what?
Caesar to the weapon, man. To
Weapon.
the offense, yes.
And then you said 1 and 3 are also Caesar witness.
Yes, my lord. There are, or should they have six?
All
for the
for the
signature.
all for
I
the
have to
weapon.
go through once again, my lord. My note says it's a Caesar witnesses.
He's a witness of what without a fear?
Yes, my lord.
And
Let us see the Caesar list, my lord. Page 57.
X over X.
X, my lord. Caesar of X. Page 57. Where in name of 3 persons are there. Bhagavan Burman, PW1. Nareswar Deka, PW3. And Bhagirat Bejburua.
he's not here.
Here,
Well,
PW5.
Number 10,
PW5 is Bhagirat Bejburua.
PW5. Yes.
Yes. Then Lordship, PW6 names Sonali.
The one AXA.
Yes,
AXE.
X, my lord.
AXE it should be.
Yes, it's written
Yes.
as AXE only.
Huh?
X is written, spelling is like that.
AXA.
XE.
I know, but out here it's page 57. Look at
Yeah,
57.
XE likha hai. Okay. Oh, one Xa with bamboo handle. With black steel. Lordship, here, the star witness is PW9, my lord.
Daiji Thakur. This is a daughter or daughter.
Of the accused as well as the deceased.
And number 10 is SI.
IO.
IO.
8 is the doctor. My note says, yes, PW6, PW7 has been declared hostile, although it's just is a witness. Has been declared hostile by the prosecution. Let us see the evidence of PW1, my lord, first. At
No,
page 8.
why go to W1? Go straight to PW9.
Okay. But one of the parts she has seen, but PW1 raised
Okay.
custody because spontaneously he's seen the occurrence. Fine.
He has seen the occurrence.
No, not seen the occurrence. It has come to his knowledge, my lord. Let us see PW1.
Okay.
Page 8. I know informant Sadananda Deka and accused Madan Thakuria. I also know this is Nila Thakuria, the wife of the accused. Incident took place on 1/6/13. The incident took place at around 1:30 p.m. Accused married daughter of my maternal uncle. On the previous day of the occurrence, a quarrel took place between the accused with his neighbors. So he spent the night at our residence. On the day of occurrence, he took a dowry from our house. And after inquiry, I could know that he proceeded to Belsor PS. I, along with her relative, went to the Belsor PS, and as per advice of the OC, we took him back to his residence. I also came to his house riding my bicycle. Accused returned to his residence in a motorcycle being driven by his nephew Bolen Thakuria. We followed them. As soon as we reached the house of the accused person, we have heard that accused given an axe blow on the head of his wife Nila Thakuria, resulting death on the spot. We then went to the house of village headman. I saw the dead body of the deceased in the room of the accused. At that time, some relatives and local persons were present there. The villagers also rushed to apprehend the accused to the house of the village headman. Village headman informed the police and police came. Police took him to the police station. Police seized one axe having bamboo handle with blood stain. Exhibit 1 is the scissor list and Exhibit 1 is my signature. The axe was seized at a place of occurrence being found nearby the deceased. Thereafter, Executive Magistrate Kamsio of Posim Nalbari Revenue Circle came to the place of occurrence and prepared the inquest report. And on the dead body of Nila Thakuria, wife of Madan Thakuria, Exhibit 2 is the inquest report and Exhibit 1 is my signature. The dead body was sent to SNK Civil Hospital by police for postmortem examination. After postmortem examination, the dead body was taken to the village and public of the locality cremated the dead body, so and so. House of the accused is situated at a distance of about 10 kilometers from Belsor PS. It may take 20 minutes from traveling from Belsor PS to the house of the accused. I was returning from Belsor PS to the house of the accused riding my bicycle. At the time, Sadananda was also riding bicycle from Belsor PS to the house of the accused. While I reached near the place, I found the accused person running from the gate, my lord. So, lordship, prior to the occurrence and subsequent to the occurrence, this witness was there. I found the accused person running from the gate of his house. I did not notice any weapon in the hand of the accused at that time. I did not call him since he left the place running. Dead body of the deceased was lying inside the room and the axe was lying at the veranda attached to the room. I did not see who left the axe at the veranda. My house is situated at about 3 kilometers from the house of the accused. I cannot remember now whether I have stated before the police around 1613 at around 3:45 p.m. I was at my residence. It is not a fact that I stated before the police that hearing halla, I came out from my house and could know about the occurrence. It is a fact that I did not state before the police that the axe was lying at veranda. It is not a fact that I did not state to police while I reached nearby the place of occurrence. I found the accused person running from the gate of his house. It is not a fact that I did not state to police that on the day of occurrence a quarrel took place between the accused with his neighbors. Police obtained my signature exhibit 111 at the police station. I cannot remember whether anything was written in exhibit 1. Police obtained my signature in the exhibit 2 at the police station on the next day of the occurrence. I did not know for that purpose police obtained my signature in exhibit 1 and 2. Since articles X is not available before the court today, police obtained my signature. Exhibit 11 is the police station on the next day of the occurrence. Neela Thakure is the daughter of my maternal uncle. It is the fact that I did not state to police the accused went to the house of village headman running. It is not a fact that I have deposed falsely. Lordship, may I take your lordship straight to the evidence of PW9 now at page 22. She is the eyewitness, man. Page 20.
Yes.
She is the daughter of the deceased and daughter of the accused too. I know the informant, Sadananda Deka, who is my maternal uncle. I knew this is Leela Thakuria, who was my mother. I know the accused person present at the dock, who is my father. The occurrence happened at around 4-5 years ago. During that period, I was unmarried and I stayed at my home situated at Makrapar village under Belsor PS. The occurrence happened at about 4 p.m. The accused used to quarrel frequently with my mother, myself, and other family members, as well as he used to cause torture upon us. He used to torture us in both his intoxicated and unintoxicated state since 4-5 years prior to the incident. On the day of occurrence at around 4 p.m., while my father and mother were talking in the middle room of our house, at that time, I went for taking bath. At that time, I heard the scream of my mother. I immediately rushed to the room and noticed that my father inflicted injury at the neck of my mother by means of an axe. I also noticed that already my father inflicted injury by means of an axe upon my mother twice. I noticed the last blow inflicted. She seen the occurrence, my lord. Notice the last blow inflicted by means of an axe by the accused on the neck of my mother. Due to the said blow, the head of my mother was also severed from her body. Thereafter, my father left the axe at the pew and went out from the house with a lathi in his hand. I raised the and cry, and my sister Pompi Thakuria, many neighbors and relatives appeared at the pew. My maternal uncle also came to the pew receiving the information, and maternal uncle brought my mother to the hospital, although she already expired. Later on, the dead body of my mother was brought from hospital and cremated at our village. The accused also inflicted injury on my sister Pompi prior to 1 year of the occurrence. Presently, my father threatened me and my brother with dire consequences. Then in cross, my lord. After the occurrence, my father went to matrimonial house once and did not visit again. The quarrel occurred between my mother and father due to trifling matters. At the time of occurrence in our family, there were 5 members, including my mother, father, elder sister, and 1 brother and myself. On the day of occurrence in the morning house, all the family members were present at the house and we took lunch together. My parents were talking to each other since 5-10 minutes while I left for bathroom. The bathroom is situated at the backside of our house. It is not a fact that I did not state before the police that I witnessed my father inflicting the last blow at the neck of my mother. It is not a fact that I did not state before the police that my father inflicted 3 injuries at the neck of my mother by means of an axe. It is not a fact that my father stated that he will catch the culprits and by saying that he went out of our house. It is not a fact that I deposed falsely today regarding inflicting injury by my father upon my mother and witnessing the incident. It is not a fact that I did not state before the police that my father used to torture myself and other family members, including my mother, both intoxicated and unintoxicated state since last 4-5 years of the occurrence.
Just in that. Thank you.
Another important notice is PW4, in whose house he was taking shelter, my lord.
What the?
Shelter, my lord.
Why?
After that,
He was hiding there.
I think
He is Lat Kondol, my lord. Daubura.
PW4.
Fourth. At page 14, and there is extrajudicial confession.
In PW4.
Yes,
Before PW4.
PW4, my lord. I know Sadananda Deka and accused Madan Thakuria. I knew his wife Meera Thakuria. The incident took place about 3 years ago. The house of my accused is situated 1.5 furlong away from my house. Around 2:33 p.m., the incident took place. At the time, I had been sleeping. Then the accused rushed to my house and said, "Save me, Bormonda." When I asked him, he said, "I hacked Leela. Please save me," and informed the police. As I got perplexed, I kept thinking about it. He remained in my house. Thereafter, I came to know that people armed with sticks and spears were proceeding towards my house. I kept the accused in my drawing room and informed the police. After 45 minutes, police came to my house. Police came, keeping the accused guarded by the police in my house. They took me to the house of the accused. I saw the wife of the accused lying prostrate inside the house with bleeding injury on her neck. Police examined the dead body and thereafter prepared some documents. Police took the accused to the police station.
So he was arrested from house of
Yes,
PW4.
yes. Then my cross-examination. When the accused came to my house, there was no weapon in his hand. I talked with the accused for about 20 minutes. He told me that the above facts at that time. It is not a fact that I did not state before the police that the accused told me that he had come there after hacking Leela. It is not a fact that, it is a fact that I did not state that when I arrived at the house of the accused, his wife was lying prostrate with injury on her neck. On the day of the incident, police recorded my statement in the house of the accused. It is not a fact that the accused did not tell me that we had hacked his wife. He said. Now, I take your lordship to the evidence of PW8 is doctor, madam.
PW?
8.
8.
Yes, doctor.
Not required.
Yeah. PW8, madam, doctor.
I think we have heard.
Madam.
Yes.
Okay.
Yes, sir.
Lordship, the 300 statement, he took the plea of alibi. To that effect, I have got a judgment.
Where, what?
Question number 6, page and 18.
But
madam.
no, my lord, in cross
Page
exam.
27.
Huh?
Page 27.
Page 27. Yes.
Question number 28 is, I have nothing to say. It is a false allegation put against me. I was working as an electrician in Guwahati during the time of incident. I didn't know, sir. I have got judgment to that effect.
Yes.
Plea of alibi has to be proved by positive evidence. Just taking plea will not be. Listen, it is 97 1 SSC 283. There are 22 and 23.
Can I?
22 and 23. Para 22. We must bear in mind that an alibi is not an exception, special or general, envisaged in the Indian Penal Code or any other law. It is only a rule of evidence recognized in Section 11 of the Indian Evidence Act that facts which are inconsistent with the fact in issue are relevant. Illustration A given under the provision is what reproducing in this context. The question is whether A committed a crime at Calcutta on a certain date. The fact that on that day A was at Lahore is relevant. The Latin word alibi means elsewhere, and that word is used for convenience when an accused takes recourse to a defense line that when the occurrence took place, he was so far away from the place of occurrence that it is extremely improbable that he would have participated in the crime. It is the basic law that in a criminal case in which the accused is alleged to have inflicted physical injury to another person, the burden is on the prosecution to prove that the accused is present at the scene and has participated in the crime. The burden would not be lessened by the mere fact that the accused has adopted the defense of alibi. The plea of the accused in such cases needs to be considered only when the burden has been discharged by the prosecution satisfactorily. But once the prosecution succeeds in discharging the burden, it is incumbent on the accused who adopts the plea of alibi to prove it with absolute certainty so as to exclude the possibility of his presence at the place of occurrence. When the presence of the accused at the scene of occurrence have been established satisfactorily by the prosecution through reliable evidence, normally the court would be slow to believe any counter evidence to that effect that he was elsewhere when the occurrence happened. But if the evidence adduced by the accused is of such a quality and of such a standard that the court may entertain some reasonable doubt regarding his presence at a scene when the occurrence took place, the accused would no doubt be entitled to the benefit of that reasonable doubt. For that purpose, it would be a sound proposition to be laid down that in such circumstances, the burden on the accused is rather heavy. It follows, therefore, that strict proof is required for establishing the plea of alibi. This court has observed so on earlier occasion, Dudnath Pandey versus State of UP and State of Maharashtra in Narsingh Rao Gangaram people. So he has to give positive evidence to that effect, my lord. And on the point of
Yes.
on the point of extrajudicial confession, may I refer AR 75 Supreme Court 1320, para 5. Ready? Maghar Singh versus State of Punjab.
What is the citation?
AIR 1975, Supreme Court 1320. And it is also reported in SCC. SCC 75 for SCC 240.
1975. What?
241. I'll be citing para 5, my lord. Para 5. The second contention put forward by the learned counsel for the appellant was that there was no material corroboration of the statement of the approver and the High Court.
241, page 241.
I'm taking AIR 1975.
Huh?
AIR 1975.
Gajendra Singh.
No, Maghar Singh.
Magar Singh is something as what?
It's on, I'm
You know the
relying on the
case-
point of extrajudicial confession. 241.
241 is Gajendra Singh.
Gajendra Singh.
What way to do is? AI आपने SCC दिसे. SCC 24. Oh. AI 9 SC 1320. Yes.
It's a different case.
Oh, I don't know, but my Manupur.
You are taking all these citations from where? I hope it's not Chat GPT or something like
No,
that.
no, AI online citation, man. Ekon diog na. Case to mili se to. Ekon dite.
Yes.
Oh, case to milana hai. Para 5. I said
You print out, no? Another one.
the printer.
Why you don't have? In 1975, 4 SPC,
241,
Yes.
241.
241, correct. I
No,
said,
Correct.
correct,
They have
correct.
wrongly kept. This is wrong. 75 for it's It's again 341 if there is Magarsi 341.
Why to side you, the index for side you.
Just give me that. Give me that. Give me that.
Index for side. I said it.
No, 234.
Put लिखा है इसमें print to दियो ना एक मिनट para 5 man more particular the fifth line. The evidence furnished by the extrajudicial confession made by the accused witnesses cannot be termed to be a tainted evidence, and if corroboration is required, is only by way of abundant caution. If the court believes the witnesses before whom the confession is made and is satisfied that the confession is voluntary, then in such a case, conviction can be founded on such evidence alone, as was done in Rao Shib Bahadur Singh versus State of Vindhya Pradesh, AI 1954 ST 322, where the lordships of the Supreme Court rested the conviction of the accused on the extrajudicial confession made by him before two independent witnesses, namely Gadkari and Perulkar. In the instant case also, after perusing the evidence of PW 3 and 12, were satisfied that they are independent witnesses before whom both the appellant and the accused Surajit Kaur made confession under guilt, and this therefore forms a very important link in the chain of circumstantial evidence. In our opinion, the argument proceeds on fundamentally wrong premises. The extrajudicial confession is tainted evidence. Then on the point of my lord, eyewitnesses account, Roshan, may I refer one judgment of the Honorable Supreme Court by saying Chandan versus State. There are 5. Xerox 2. The latest judgment of 2024, April 2020.
Which para are we relying?
Lordship para 5, although they have not taken the plea, the no motive and all, in eyewitnesses account, no motive is required. The argument of the defense that the prosecution has not been able to establish any motive on the accused for committing this dastardly act is in fact true. But since this is a case of eyewitness where there is nothing to discredit the eyewitness, the motive itself is of little relevance. It would be necessary to mention some of the leading cases on this aspect which are as under. In Shivaji Genu Mohita versus State of Maharashtra,
Motive is not required.
my lord. Lordship, then on the point of race ST, Lordship, may I refer 2009 6 SCC 450. Zabir Alam versus State of Chhattisgarh. Para 19. It starts as my lord, Section 6 of the Evidence Act is an exception to the rule of evidence that hearsay evidence is not admissible. The case for applying the rule of res gesti is that the statement should be spontaneous and should form part of the same transaction, ruling out any possibility of concussion. In Gentila Vijayan Rao versus State of AP, it is held in para 15 as follows. Section 6 of the Evidence Act and some of the succeeding sections embody the rule of admission of evidence relating to what is commonly known as res gestae. They are in the nature of exception to hearsay rule. Section 6 permits proof of collateral statements which are so connected with the facts and issues so as to form part of the same transaction. Whether the statement made by a witness was a part of the same transaction or not is to be considered in the light of the circumstances of each case. The principle is that it would be so intimately connected with the fact and issue so as to be spontaneous utterance inspired by the excitement of the occasion or a spontaneous reaction thereof. There being no opportunity for deliberately fabricating the statement. In other words, the statement which is the part of risk state does not narrate a past event, but it is the event itself speaking through a person, thus excluding the possibility of any design behind it. Then, Lordship.
Yes.
Lordship, another aspect is that daughter who happens to be the eyewitness, she has said that all the person accused as well as the other family member is to, as well as the deceased is to reside in the same room. Given the accused interrogator statement, answer to question number 6, do you reside in the same house where your wife stayed till your death? He said yes, at page 28.
Sure.
So he could not deter, he was, an explanation is what from him, but under what circumstances, which he could not deter. Under
Okay, the
106.
eyewitness,
My lord.
what you, that's not the question.
That much I have to say, the prosecution to prove the case beyond all reasonable doubt, my lord. As a result of it, the lordship may appeal the conviction.
Yes,
Well, Chief Lanathan has already read over the statement of PW1 and PW9.
PW4 also.
PW4 also. PW4 was the village headman. And PW1, my humble submission, the PW1 stated that on the previous day, the accused visited his house and he spent night there. And from his house, he went to the Belser police station. And thereafter, at around 1 and 1:30, he went to his own house. And they followed, and PW1 and 2 followed the accused by bicycle. Accused went to the motorcycle. So they followed. And when they approached, when they reached the place of occurrence, they saw that accused ran away from his house. So, my lord, whereas PW9, she stated all of them were getting their lunch. At that time, all were there, and there was some altercation, and he was roaming around. My lord. So these are, my lord, material, my lord, contradictions.
Just means that you see, because sometimes maybe someone has just entered the house and the daughter might have been in another room and she just came and sit down. He's not going to say from where he came or what. No one knows.
No, my lord, I am saying that it took 10 kilometers away from the Belser police station to
No, you see
to
one
his
thing.
house.
You just go straight to PW9. Let us not go to PW9. Why
Yes.
should she tell a lie? Why should your daughter tell a lie that you had
My
killed
lord,
your mother?
in her statement, in the before the court, my lord, she stated that more often in drunken state, the accused used to, my lord, scold them and used to, my lord.
Correct.
But in 161, she never stated those things, my lord.
Okay, but then so once it's
She may-
will not corroborate.
So she may be tutored, my lord, and her statement was her statement by the, my lord,
Have you-
police.
Did you put any suggestion to her in your cross-examination that she was tutored?
No, my lord, that is. And my lord, her statement, 161 statement was recorded 1.5 months later after the incident.
So,
That is also one of the because she, my lord, she got enough time to refresh her mind my lord, to give statement. Had it been, my lord, within a, my lord, immediately after the occurrence,
Lordship, page 25, the IO, last line. Witness Daisy Thakur in his statement recorded on 161, before the police stated that her accused father cut the neck of her mother. I did not use the word gave last play. So she has stated before the police, my lord.
where is the suggestion that she's telling a lie?
that is not there.
Huh?
That is not there. But some suggestions are there that those statements were not before the police.
That is neither here nor there. Where is the suggestion that she has fabricated the her evidence?
Exactly, that suggestion is not there. But my lord,
Difficult.
and my lord, Caesar list, my lord, where the murder weapon was recovered. The one witness PW3 has stated his signature was taken in a blank paper.
Yeah, maybe, but then you tell me, okay, did
So
you,
he
so
doesn't
what
know.
is the evidence of that village headman.
Yes. Village headman,
Is that-
PW4.
Is that what is wrong with the evidence?
PW4 also, my lord, in his statement, he stated in cross-examination part, I am reading just to, I'll take 2 minutes, my lord. When the accused came to my house, there was no weapon in his hand. I talked with the accused for about 20 minutes. He told me the facts at that time. It is not a fact that I did not state before the police that the accused told me that he had come there after hacking Leela. So earlier, my lord, this statement was not there in the police before the police. It is a fact that I did not state that when I arrived at the house of the accused, his wife was lying prostrate with injury on her neck. On the day of the incident, the police recorded my statement in the house of the accused. It is not a fact that the accused did not tell me that he had hacked his wife. So only that much. No. And
What is wrong with the cross-examination? Nothing has been checked.
that is true, my lord. But I am only on the, my lord, to be a, my lord, styling witness. To be only to my lord, convict a person only on the basis of a sole witness, my lord.
One week, there is a.
Yes, my lord. Yes.
You give me one, I'll give you the other doesn't. One witness is enough. There's so many.
That is true, my lord. One witness is enough. If, my lord, her statement during the investigation, before the court remains, my lord, consistent. If there is any inconsistency, my lord,
But one thing you just have to show, where is your suggestion that your daughter's evidence was false? There is a suggestion to her that she has fabricated her evidence. Only then can we go into those.
yeah.
What they're trying to say, that this has been put, these questions have been put to the IO.
IO, my lord, what happened? IO died, my lord. Subsequently, IO died. So that
Okay.
is why he could not be cross-examined. OC has submitted the charge sheet, so he was cross-examined.
So he did not.
So he could not be examined. IO.
And what is the, and if the IO cannot be examined, is it a case for acquittal?
My lord, that in that accused will not suffer, perhaps, my lord. That is inevitable, my lord, because
No. There are
some
judgments.
questions, my lord.
There are judgments even passed by this division ways.
I have,
And
I,
IO need not be examined.
I have, yes, my lord, for non-examination of IO prosecution case is not, will not suffer from any, my lord, that judgment I have. But my lord, whether, due to death of the, my lord, IO, whether accused will get any benefit or not, that doesn't.
No.
His IO who is before the court, my lord, not a trial court. Everything was with him, like it was duly exhibited. His diary and all, everything was with him. Then what is about?
There's no case. Now, I'm trying to look out, but don't doctor, no suggestion that you have,
Yes.
that he has fabricated or told a lie.
In this judgment, my lord, lordship, I have, I am the only, my lord, referring paragraph 12, 13, 14, and 15.
Which judgment?
This judgment I have submitted, my lord, recent judgment.
Because this Nirmal,
Yes, ma'am. This case, regarding, my lord, rape case, my lord, 376. But here, my lord, ratio is that, my lord, what should be the character of a styling witness?
Para 15 is the ultimate correct.
Yes.
Your lordship's permission, may I leave? Vedanta. I'll be here.
okay.
Complex.
Right, Sandeep. Anything else?
Nothing, ma'am.
Very difficult.
Unfortunate, because my lord, daughter stood as a witness. That is why. And that too eyewitness.
Ah. And why should she go against you?
Those, my lord, those statement, those suggestions, nothing, my lord, that is there. That is why.
And how are you going to tell your daughter? Can you discredit your daughter? I mean, it will be very difficult unless you are a monster.
Some exaggeration are there. That is true, my lord. Some exaggerations in her evidence is there.
Could be.
What, can you show anything?
Exaggeration regarding that she stated in PW9, she in page 23. Page 23 in her, I'm reading from the page 22 second paragraph. On the day of occurrence at about 4 p.m., while my father and mother were talking in the middle room of our house, at that time I went for taking bath. At that time, I heard the scream of my mother. I immediately rushed to the room and noticed that my father inflicted injury at the neck of my mother by means of an axe. I also noticed that already my father inflicted injury by means of an axe upon my mother twice. I noticed the last blow inflicted by means of an axe by the accused on the neck of my mother. Due to the said blow, this line, my lord, due to the said blow, the head of my mother was also
Was about to.
severed.
Hmm.
But my lord, from the medical evidence, my lord, the doctor's evidence, the injury measurements, that doesn't suggest that. My lord.
You see,
It's
yeah,
about to be,
about to be. You see,
About to severed.
probably the head went like this. You know, head
Maybe.
went like this. So actually, for a child, even for us, have you seen? Have you seen animals being slaughtered? I mean, practically, have you seen it with the knife going through their neck? You haven't seen
Sometimes.
sometimes.
Yes. That is true, huh?
You see, once you make a cut, it doesn't stay straight. The head doesn't stay straight anymore. You know, it's not this way, that way. And so, and for a person, young child to see that, I mean, little bit of, when two persons go to a movie, they will see the action and 100%, the correct version of that action scene will be seen multiplied by 2 or something like that. Because, some exaggeration is there with kids, usually that. And that doesn't make it any less reliable.
Yes.
I'm just saying, subject to correction.
Yes,
subject
yes,
to
well,
correction.
rightly said.
Ah.
And because being a daughter 16 years old, she might have gone some
And you
horrible.
see sometimes say some chicken is slaughtered or something like that. Or any animal is slaughtered. You see the blood coming out. You think it's like tons and tons, but actually it's not much. So it's the matter of how you perceive things. So perception is different for different persons.
Yes.
Old man and a young kid will be different.
More injury,
Poor in-
similar nature,
Yes.
almost same nature. By the
All the injuries are in vital part. That is
Underneath.
also.
one side.
Yes.
That is. Yeah, the Michael.
Yeah, my guess.
Michael. Right, Mr.
MK quality.
N.K. Kalita, Leonard Michael Stewart. Also had Miss P. Puya, additional people. The present appeal has put a challenge to the impugned judgment dated 6/8/2021, passed by the Sessions Judge Nalbari in Sessions case number 29/2020, 29/2014, by which the appellant has been convicted under section 302 for murdering, of killing his wife. Pusta. The prosecution case in brief is that an FIR dated 1/6/2013 was submitted by the brother of the deceased, who was prosecution witness number 1, bracket PW1. The FIR stated that
Informant my lord PW2.
PW2. The FIR stated that around 3:45 p.m. on 1/6/2013, the appellant had killed the deceased by hacking her with an axe inside the house. Pursuant to the FIR, Belsor PS case number 54 of 2030 and the section 302 IPC was with it. The investigation was thereafter initiated, and on completion of the investigation, the case IO, the investigating officer submitted his charge sheet, having found a prima facie case under section 302 IPC against the appellant. So, next. The learned trial court thereafter framed a charge under section 302 IPC against the appellant, to which he pleaded not guilty and claimed to be tried. The learned trial court thereafter examined 10 prosecution witnesses and after having examined the appellant under section 316 CRP, comma, the learned trial court came to a finding that the appellant had killed his wife with an axe. The appellant was accordingly convicted and sentenced under section 302 IP. Next, the learned counsel for learned amicus curiae submits that what is your points? Give me a point.
Hello?
Point from what? Your first point is? Your point submission, your first submission.
Yes, madam.
What is
Point
it?
for determination, there is material contradiction between PW1 and PW9.
How?
Well, I have submitted the judgment that the conviction only was based only on the evidence of PW9. So, learned trial court considered her evidence as its sterling witness, madam. So, according to me, madam, there are some material contradiction.
What is the material contradiction?
Contradiction, I have stated that she has not stated before the police that there were 3 injuries.
Who had not said it? PW9 had not
Nine.
said. There were 3 injuries.
Yes, actually there is four injuries as per Dr. Mellon.
Okay, right. Whatever I said, the learned, the submits that there is contradiction. No, submits that the evidence of PW9, who is the sole eyewitness to the crime in question, is not what? Is not? What is the
Was
submission?
not consistent.
Was not consistent. In as much
Evidence
as,
of PW.
in as much as PW9 had only spoken of 2 injuries.
Three injuries.
Three injuries on the neck of her mother.
Yes.
From a while, there were 4 injuries.
4 injuries, and before police, she has stated only 1
As
injury.
per the evidence of the doctor.
Yes. PW.
Further,
Eight.
PW9 had only spoken of 1 injury.
During the investigation. Investigation.
1 injury
Police investigation.
at the time of her statement made under section 161 CRP.
Only one injury, but one and the 2 injuries.
No, only about injury.
Page 26. That the accused murderer cut the neck of her mother but did not use the word gave last blow. Then witness Daisy Thakuria in his statement recorded under 161, CRPC before the police did not state that her accused mother inflicted 3 injuries by means of an axe on her mother, but stated that her accused mother inflicted injuries on her mother by means of an axe.
The number was not given.
Yes,
Number of
falsify the prosecution case. Inconsistency. Page 26.
Anyway, that is his topic.
Yes.
Anything else?
And my lord, the PW1 and 9, that regarding the timing, my lord, that from Belfast police station, PW9 stated that all the family members were there at that time. But according to PW1, he was coming from Belfast police station. So he was not there at the time of.
That's correct. She was speaking about her family members, but means her brother, sister.
No.
Nothing-
Others-
nothing
Who is
related to-
PW1?
He's not
PW,
the-
PW1 is the, my lord, one
Uncle.
how is he related?
brother-in-law of the victim, my lord.
Brother-in-law of the victim.
Uncle.
Yes.
So why should he live with them?
He's not
He's not in the house.
No, my lord, I am not taking. No, my lord.
He's
PW1 stated that PW9 accused person came from the Belfast police station to his house, and PW1 was following him. When they reached the
Correct.
home, then they saw that accused person fled away, ran out from.
correct.
See,
So-
there is a difference there. this accused was coming by a motorcycle
Yes,
and they were followed by a cycle.
Bicycle.
So he must have reached earlier, much
Yeah.
earlier
Correct,
than
much earlier.
this.
yes.
So how can, what
So
is the
it
con-
takes 20 minutes by bicycle.
No, so what are you trying to say?
No, I am saying, my lord, PW9 said that they all were in the house at the on that day, on that.
No,
Kindly see, my lord.
no.
Kindly see, my lord. So, my lord.
See, when I say family members, I
Yes.
will talk about those who are living in my house. I'm not going to talk about my uncle and auntie and grandfather and grandmother who are living somewhere else. You see, when I say,
My lord, I am saying that.
in the cross it has come, my mother, father, elder sister and one brother and myself.
Yes.
then
He's not talking about anyone.
he's not talking.
No, I am not talking about any other. They were family member. I am saying that accused person, she stated, PW9 stated that on that day, accused person all along with them, that is not true. Because he was coming from Belfast police station, accused person.
You see, Mr. Counsel, you see, the thing is that at that, you see, when supposing, and now the say, Madam's family, B. Bhuyan's family, her children might be there in her house right now, and right now their family is incomplete. But maybe by 5 o'clock they may be complete. So at that time they were complete. He's not talking about that they were complete around from 6 o'clock in the morning or something like that. What are you trying to say? I don't know.
No, I mean, Mr. Counsel, he's talking about the incident after 4 o'clock. He was not talking about before, what happened. It was not required of. They cannot infer from there that like,
I may be wrong, but my
He's
only,
talking
my
about-
only,
You see, he's talking about 4 p.m.
yes, 4
Then-
p.m.
He's not talking about the
I am-
entire day.
No, my lord, I may be wrong, my lord. I am only submitting that I am coming from the Belfast police station, 2 persons following me, and it takes 20 minutes time. So I am coming from my Belfast police station to my home, and immediately within 20 minutes, I reach the PW1 also reached the house of the accused person.
No, PW1 did not reach the house.
20
they did
minutes,
not reach the
kindly
same
see, my lord,
place.
20 minutes, it takes 20 minutes.
may take.
Mr. Counsel.
This person accused.
You're not making sense. Your submission is not making.
No, PW9 said that
I'm trying
accused
to
person
record a-
all along with them on that day.
He-
I am only submitting that.
Okay, according to you,
that
PW9
is material contradiction.
PW1 was with them.
PW1 no, accused. That is material contradiction.
Okay,
According
right.
to PW1, accused was with him till 1:30.
Let me clarify.
While he was in the house of the PW1, there's no possibility that accused person will remain in the house and having
At the
this
same time,
together.
no. I am not talking that hacking. I am not talking, but I am only saying that, my lord, the PW9 statement that the accused person all along with them on that day, that is not correct.
It was
Where is it? Where is that all along? Please read where is it along? Where you say it? You cannot put words where they are not there.
never stated so.
On that day, on the day of occurrence at about 4 p.m.
At about
4
4
p.m.
p.m. Yes.
while my father, mother were talking in
Yes.
the middle room.
Yes.
So my lord, he
So where
after
is
lunch,
PW1?
after lunch.
Where is whether it is after dinner, after
Yes,
lunch?
my lord.
It is
161, my lord. 161, I am relying in that case. 161 statement.
Counsel, right now we are in the evidence.
But-
You cannot jump here and there just
So,
like
my lord, I am only submitting the lordship, my submission that there is material contradiction. That is what I am submitting.
where is the contradiction?
Contradiction
Where
is that, my lord. Kindly see, for a moment, my lord.
Yeah.
Only 1 minute. আজি দিনৰ 3:45 বজাত মই ঘৰতে আছিলো দিনৰ প্ৰায় 3:30 বাৰ ইট ইজ 161 মানে PW9 মই মোৰ দেউতাক ভাত খাবৰ বাবে দিওঁ 3:30 উক্ত সময়ত মোৰ মা লীলা ঠাকুৰীয়া আৰু বাইদেউ ঘৰত আছিলে দেউতা অলপ ভাত খাই গুচি আহে পিছত মই বাইদেউ আৰু মা তিনিও একেলগে ভাত খাব যাওঁ ভাত খোৱাৰ সময়তো দেউতা ওচৰতে ঘূৰি আছিল আমি ভাত খোৱাৰ পিছত বাইদেউ ওচৰত থকা বৰদেউতাৰ ঘৰত যায় বাইদেউ যোৱাৰ পিছত ময়ো গা ধুবৰ বাবে ঘৰত পাছফালে থকা বাথৰুমত যাওঁ হঠাতে মই মৰিলো বুলি চিঞৰ মৰাত মই পাছফালৰ পৰা আহি দেখা পাওঁ যে মোৰ মা তেজেৰে লুতুৰি পুতুৰি হৈ ছটফটাই আছে দেউতাই হাতত কুঠাৰ এখন লৈ থিয় হৈ আছে মোক দেখাৰ লগে লগে কয় যে মাৰক কাটি শেষ কৰি দিলো আৰু লগে লগে দেউতাই তেওঁৰ হাতত থকা কুঠাৰখন মাটিত পেলাই হাতত লাঠি এডাল লৈ কৰবাত গুচি যায়। দিছ ৱাজ হাৰ ষ্টেটমেণ্ট 161.
What is the contradiction there?
Contradiction, my lord, see, he in her court, my lord, before while deposing,
No, here also it tallies with what she was submitting before the court.
no, I am saying that exaggeration, man, exaggeration part.
Yeah, what she was stating before under
In-
161,
In
she said the same thing.
in my lord court, my lord, she has stated that I have seen that last blow, her mother's neck about to severed. In 161, she never stated. She stated that after hacking, my lord, she arrived there.
Okay, she did not talk about the neck being severed.
No.
About to be severed. That part she did not mention.
So I am only, my lord, material. I am submitting. That is my submission, lordship.
No, but your submission,
On that point, are we?
counsel,
I am on-
your submission has to make sense. And it has to be in consonance with what is before us. You
Yes.
cannot make submissions out of thin air. It has to be based on something. So you see what we are reading here. It has to be in terms of what we are reading here, not with something that is not there. So
Some suggestions were put to her, my lord. Those things were not stated before the police. So those suggestions were there. So that is why I have
No,
gone
please
through the
proceed.
record, my lord. I have gone through the record. So that is what I am submitting. So my lordship has asked me.
I have
on
asked you, but I have asked you to make your point
Yes.
so that it
My
is.
points, my lord, material contradiction on her.
Huh?
The material contradiction in her deposition.
Contradiction with what?
With contradiction with what? Contradiction in her testimony contradicts what? What is the contradiction? You see, contradiction means like this. Look, Mr. Counsel,
Yes, my lord.
the meaning of contradiction is supposing I say this is white and tomorrow I say this is black. That is a contradiction. Now, supposing I say this is white and I say this is blue, there is no contradiction because this is something. Maybe I did not mention that this is blue yesterday, but today I'm talking about this and I did not talk about this yesterday. That is not a contradiction. That is maybe you can say maybe a discrepancy because I did not make a mention of this. But contradiction is when you contradict yourself. When there's a contradiction, you say today this is black, tomorrow I say this is blue. That is a contradiction. But when I say this is white and tomorrow I don't talk about, and I didn't talk about this, but today I talk about this and this, then there is a slight discrepancy. That is not a contradiction. That is a discrepancy in as much as I did not make a mention of this in the earlier statement. That is not a contradiction. So that you see, that is why you have got to be very careful in your choice of words. When you say contradiction, it has to be you are talking about the same thing, but in two different manners. Okay. So right now, what you're trying to say here is at the time at 4 o'clock in her testimony at 4 p.m., she was there in her house, her mother and father were talking, and then the other family members were. And this has been again clarified in her cross-examination where she says, including my mother, father, elder sister, brother, and myself. So there is no, where is the contradiction with regard to who was present in that room? Does in the 161 statement, is it the statement of the this daughter that even PW1 was there in the room at that time? Then that is not a
No,
contradiction.
I am not talking about the presence of PW1, my lord.
Uh-huh.
I am only talking that he is coming and immediately after he ran out. So regarding lunch, regarding their family discussion, those were not there.
Okay, she did not mention certain things in her one
within
six
that
one
short period of
statement,
time.
which were there in her evidence.
Yes. So
But how,
those things were not
how
possible.
does that go to the root of the matter? Because
That
the
cannot go to the root of the matter, but I am submitting that these are the exaggerations. And she never stated in her 161 that her father used to torture them under the influence of alcohol. Never. But in deposition, she brought those allegations.
no, anyway, but how does that
Because
how does
Lordship,
no, just listen. Supposing, okay, he used to torture them under the influence of liquor. But that is not the issue to be decided here. The issue is not the
I am
issue of
thinking about the
whether
motive, my lord, motive. Why she, my lord,
No,
why
I'm not
she
on. You see,
implicated the father?
you see, the issue is not that. Okay, you see, you're
Why?
not getting the picture.
Yeah.
In a case where there is an eyewitness to the crime, Supreme Court has held that motive is not required to be proved. It is, you don't have to establish motive. It is only in a case where there is circumstantial evidence. And to prove that someone has killed, then motive becomes very important. Otherwise, how are you going to connect that accused with the crime? Okay, that is where motive becomes important. But supposing today I see this fellow killing this fellow right in front of me, is it required for me to know that they were their enemies or they used to hit each other? I've seen them killing, it's enough. That is what is required to be proved. Because you look at 299 says culpable homicide. Section 300 talks about culpable homicide amounting to murder and what are the requirements. And except if they come under the exceptions, then unless they come under the exception, then 302 is applicable. Otherwise, it goes to 304. So out here, you, you see, the thing is that what took us on a tangent was that you had spoken of basically maybe the discrepancy in her statements made to the effect that some things which she had stated here in her testimony was not reflected in the 161. But you cannot use the word contradiction. Contradiction is not there. Only thing is that maybe out here there is a little bit more masala according to you.
Yes, exaggeration.
Exaggeration. That's all.
That is all.
Ah.
Minor discrepancies were accepted. Major
So according to you, what is the major discrepancy?
Major discrepancies, those are, my lord, that in her 161, she had not stated that she has saw her father inflicting the blow. In 161, she never stated.
What did she say?
She stated that she heard the sound of screaming of her mother and she came out from the bathroom and saw her mother fell in the floor. And father said, I have killed her.
Oh, and she heard her father say that.
Yes.
And the father was holding the axe.
Yes.
He saw that also.
Yes.
Is that correct?
We read just now, I have not gone to the records, but
Yes.
the statement.
Give the 161. Yes. Give the case report. No, you have to. Buyan. So what have I said? He also submits that there was a discrepancy. There submits that certain things that she had stated, that the PW9 had stated in her testimony before the trial had not been stated by her under section 161 CR. PW1 had not stated the fact that she had seen her father inflict the last blow on her mother with an axe. PW9 had stated that had not stated the fact that in her statement under section 161 CRP, though the same had been stated by her in her evidence. He also submits that he also submits that PW9 did not state before the police that the her mother's head was about to be severed from her body due to the blow, due to the axe blow made by the father of PW. However, the same has been stated by PW9 in her testimony before the Senate trial. That's all. Anything? That's all.
Just now he has read out. No, you have read out
Yeah.
somewhere. You have.
I have read out from, I have written from there.
Statement of Deji Thakuria, ওপৰত উল্লেখ কৰা মতে মোৰ নাম আৰু ঠিকনা সত্য। মই স্কুলত পঢ়ি আছো। আজি ইংৰাজী 1/6/2013 তাৰিখ দিনৰ প্ৰায় 3:45 মান বজাত মই ঘৰতে আছিলো। দিনৰ প্ৰায় 3:30 মান বজাত মই মোৰ দেউতা শ্ৰী মদন ঠাকুৰীয়াক ভাত খাবৰ বাবে দিওঁ। উক্ত সময়ত আমাৰ ঘৰত মোৰ মা লীলা ঠাকুৰীয়া আৰু বাইদেউ শ্ৰী পম্পী ঠাকুৰীয়া আছিল। দেউতাক অলপ ভাত খাই গুচি আহে। পাছত মই বাইদেউ আৰু মা তিনিও একেলগে ভাত খাওঁ। ভাত খোৱাৰ সময়ত দেউতাৰ আমাৰ ওচৰে ঘূৰা-ঘূৰি কৰি আছিল। আমি তিনিও ভাত খাই উঠাৰ পাছত বাইদেউ ওচৰতে থকা বৰদেউতাৰ ঘৰত যায়। বাইদেউ যোৱাৰ পাছতে ময়ো গা ধোৱাৰ বাবে ঘৰৰ পাছফালে যাওঁ। হঠাৎ মায়ে মৰিলো বুলি চিঞৰ মৰাত মই পাছফালৰ পৰা আহি দেখা পাওঁ যে মোৰ মায়ে মাটিত তেজেৰে লুতুৰি পুতুৰি হৈ
No, he'll translate now.
লুতুৰি পুতুৰি হৈ ছটফটাই আছে আৰু দেউতাই হাতত এখন কুঠাৰ লৈ মাৰ ওচৰতে থিয় দি আছে। মোক দেখা পোৱাৰ লগে লগে দেউতাই মোক কয় যে মাৰক কাটি শেষ কৰিলে। So
Yeah.
there's extrajudicial confession also to that effect.
No, sir, tell me.
Only difference is what he was submitting is that the actual blow, the last blow.
That he did not, that she did not mention that.
He is not.
But what about the body, the head about to be severed, that has been stated.
Shit, may I proceed?
That also, she did, that
So
was,
she was lying there
Ah.
with all blood and all,
Oh.
and the eggs was holding by her.
okay. So, and then he had also said that he killed her, killed his
Yes,
wife.
yes, I killed your mother.
I killed your mother.
In my opinion, my lord, in my considered, my lord, that these are major discrepancies. Because
Not
if,
at
my
all,
lord,
not at all.
if-
Not- You see, if there are contradictions, if it, that is not a major discrepancy.
They're very minor ones,
These are actually, these are,
very minor ones.
you see, I don't know, how can you say, I understand if you see, it is conflicting discrepancies. It is not conflicting,
Well,
it's all
one-
pointing towards one act.
and if,
Only the aspect of last blow was missed out. That's all. Nothing else.
The accused is holding the weapon of offense.
Holding the
It
weapon,
was
He
to,
himself said-
maybe doing a war dance or something like that. Or something.
that's
He
not how
was
much
his
of measure,
residence.
that part is exaggeration. Because immediately after incident, she said that I have come to the spot only after occurrence and I have seen her lying on the floor. But in the before court, she said that I have saw that the last blow I have seen neck about to sever.
Why not? Sometimes everything is something, sometimes things happen in a flash. Okay, and sometimes they see it, but they don't mention everything. There is that, wait. For a minor, there is a decision by the Delhi High Court with regard to recollection of events and giving a clearer picture of events. Yes. I think I'll put that down. Yes. There is a judgment. For minors. Yes. You see, they not only recollect, but you see, they are quite traumatized. They are traumatized when they see things. And when you see your mother being killed by your father, how much more can you be traumatized? Tell me, won't that be the most traumatic experience for you? Supposing you see a stranger killing a stranger, that will be traumatic, but imagine seeing your father killing your mother.
If Malad, he killed Malad, or for that blow she died, Malad, that he deserved to be punished. But Malad, at the same time, the person at that time he was 41 years of old, Malad, the accused at the time of occurrence. So Malad, now he is serving the life sentence. So that is Malad, my humble submission.
No, whether that can, I mean,
Anyway, yes.
whatever the contradictions or like discrepancies you are saying, that makes the daughter's evidence unreliable.
You mean to say daughter is a
Because,
liar?
Malad, the punishment more the
What
Malad,
is your basic submission? I mean, why you are saying all these things? Because you want to say that this daughter is not reliable at all. That's what
no,
you're
I cannot say Malad,
Then
because Malad,
You see,
I am
you forget that you're an amicus. Don't forget you're an amicus.
Malad,
A job of an amicus,
to assist the court.
yes,
Yes.
you have to assist the court.
I am just
Now,
trying to point out for your lordship the
you are
facts.
trying to assist the court. You don't exactly know how you're trying to assist. Because you are not sure.
That is why, my lord, I have trying to, my lord, place all the records before your lordship.
So we are asking you, see, because you've got to be very clear in your head whether the issue is that the daughter is a liar.
No.
Is not a credible
I cannot
witness.
say.
Is not a credible witness. If your case is that she is not a credible witness, then you have got to go hammer and tongs at it. You cannot go part way. You cannot go partly credible, partly not credible. You know, you have got to take a stand. Otherwise, what you're doing right now is you're saying, okay, believable, but not too believable. And so you have got to you see so where do you draw the line?
Because well, those suggestions were not there. That is why.
Anyway, right. Right. Whatever. Next. Mr. B. Bhuyan, on the other hand, submit that the statement made by the appellant before, no, the statement made by PW9 under section 161 has not mentioned the fact that she had seen the last blow made by her father. The last blow made by an axe by her father on her mother's neck. And further, PW9 did not mention that the neck of her mother was about to be severed in her statement made under 161 CR. However, PW9 in her statement made under 161 CRPC has clearly mentioned the fact that she saw her mother lying on the floor with blood coming out. with blood coming out,
Yes.
with blood coming
full-
out,
Full with blood.
with blood coming out. And her father holding an axe. Who's the father? Her father had told her that he had killed her mother.
Finished her.
That he had killed her mother. Next part. The learned additional PP submit that the appellant in his examination under section 3(1) CCRP had taken an alibi that the allegation made that the evidence recorded against him was false, as he was working as an electrician at Guwahati during the time the incident occurred. So, he submits that the alibi of the appellant is a false statement when it is considered against the evidence of the prosecution witnesses who had seen the appellant on the date of the incident. In which village is that? In
Village Pali.
village Vijaynagar, Kamrup rural.
Village Sandeli,
Yes.
Sandeli, Makarpat.
No, because PW9 is of that, no?
No, well, she got married, my lord, subsequently.
Okay.
She got married.
Okay. Then it will be
Sandeli.
Resident.
Makrapat.
Yes.
Sandeli, Makrapat.
Sandeli,
okay,
Matra,
look at that, huh?
PS Bells.
Belson.
Sandeli Market, Makrapat.
So according to you, you are not there in the place of occurrence, in the
That-
place of incident.
That, my lord, I am not placing because, my lord, I am not placing because no evidence was, my lord,
No, this
adduced.
is your explanation.
Yes, explanation only, my lord.
So surprise, take. The learned people further submit that the evidence of PW1 clearly shows that the appellant was in the was in his village and had been seen leaving his house after killing his wife on the date of the incident. He further submits that the appellant had made an extrajudicial confession to the village headman on the date of the incident when he rushed into the house of the village headman and asked him to save the appellant. He further told PW4 that he had killed his wife and asked him to inform the police. So, the learned additional PP submit that when the evidence of the daughter of the appellant and the deceased, that is the PW9, had clearly shown the fact that he was an eyewitness to the killing of her mother by her father. Of there was nothing more. There was no requirement of any further witness, inasmuch as it was not the case inasmuch as no suggestion had been put by the appellant to PW9 that her evidence was a lie and had been fabricated. We have heard the learned counsel for the court. As can be seen from the evidence recorded by the learned trial, PW9 had seen her father inflict injury upon her mother's neck with an axe, which made her mother's head about to be severed from her body. There is no suggestion put to PW9 by the appellant that the evidence was false and that he was not a reliable witness. The evidence of PW9 is to the effect that on the day of the occurrence at about 4 p.m., while her mother and father were talking in the middle of their house, she went to take a bath. Thereafter, she heard the scream of her mother. On immediately rushing to the room, she noticed her father inflicting injury on the neck of her mother with an axe. She also noticed that her father had already inflicted injury twice by means of an axe on her mother. She also noticed the last blow inflicted by her father on her mother with an axe, due to which her mother's neck was about to be severed, due to which her mother's head was about to be severed from her body. Thereafter, her father left the axe and went out of the house with a lathi in his hand. On raising a hue and cry, her sister Pampi Thakuria, neighbors and relatives appeared at the place of occurrence. Her maternal uncle also came to the place of occurrence and took her mother to the hospital, although she had already expired. Later on, the dead body of her mother was brought to the village and cremated. On perusing the cross-examination of PW9 by the appellant, we noticed that no suggestion had been put by the appellant that the evidence of PW9 was a lie and had been fabricated. So, next part. The evidence of PW4, who is the village headman, is to the effect that while he had been sleeping in his house, the appellant rushed to his house and asked him to save him, asked him to save the appellant. On asking the appellant told PW4 that he had hacked his wife. He accordingly asked PW4 to save him and to inform the police. Thereafter, PW4 thereafter stated that he came to know that people armed with sticks and spears were proceeding towards his house. He kept the appellant in his drawing room and informed the police. The police later came. The police came 45 minutes later and guarded the appellant. Thereafter, they took PW4 to the house of the appellant, where he saw the wife of the appellant lying prostrate inside the house with injury, with bleeding injury on her nape. Nape? Nape, first up. Next up. PW1, who is the with PW1?
Brother-in-law victim.
PW1, who is the brother-in-law of the victim, of the deceased, is to the effect that the appellant had spent the night in his residence the night before. And on the day of the occurrence, the appellant had taken a dove from his house. And after inquiry, he could learn that the appellant had proceeded towards Belsor police station. On reaching Belsor police station, PW1 took the appellant back to his residence. The appellant rode a motorcycle being driven by his nephew Balen Thakure, while PW1 followed on a bicycle. On reaching the house of the appellant, they heard the accused give an axe blow on the head of the deceased, resulting in the death of the deceased. They then went to the house of the village headman. In his cross-examination, PW1 stated that when he reached the place of occurrence, he saw the appellant running from the gate of his house, and he did not notice any weapon in the hand of the appellant at that time. Next one. As can be seen from the evidence of PW4, there was an extrajudicial confession made by the appellant to the PW4, stating that he had killed his wife with an axe. In the case of Magar Singh Supra, the Supreme Court has held that the evidence furnished by an extrajudicial confession made by an accused to witnesses cannot be termed to be tainted evidence, and if corroboration is required, it is only by way of abundant caution. Gustav. If the court believes the witnesses before whom the confession is made, and it is satisfied that the confession was voluntary, then in such a case, conviction can be founded on such evidence alone. Gustav. It thus held that an extrajudicial confession cannot proceed on a fundamentally wrong premise that it is a tainted evidence, that it is tainted evidence. Next. With respect to the alibi taken by the appellant in his examination under section 313 CRP pertaining to question number 28. Now, the appellant has claimed that he was not present in the place of occurrence at the relevant point of time, and that he was in God. This is clearly disputed by the evidence of PW 1, 4, and 9. Further, PW 1, 3, and 5 were the Caesar witnesses to the police seizing the weapon bracket act used by the appellant for committing the crime in question. The just see the arrest memo.
Yes. Yes, my lord.
What is the date?
Date of arrest 2/6/2015. Date of offense
On the reason he was taken into custody.
Where?
2/6/13 mentioned.
Where? Arrested where?
Belsor PS. Shown as
Belsor PS.
menu of arrest, Belsor PS.
Further, the arrest of the appellant had been made in Belsor PS. In the case of Vinay Kumar Singh versus State of Bihar, the Supreme Court has held that strict proof is required for establishing the plea of alibi. In the present case, the evidence of the prosecution witnesses clearly show that the appellant was in Belsor village. Belsor village?
Belsor PS. Police
Belsor,
station.
no. What village is that? Where was
Yes, it was offense.
Delhi. So Delhi, Makrapara.
It's at Belsor PS.
Centrally Matapala village on the date of the incident. And as there is no proof that the appellant was in Guwahati on the said day, the alibi of the appellant being in Guwahati on the said date of the incident cannot be accepted by us. Anything else? Next para. Yeah. Further. We are of the view that the bold plea, ELD, bold plea of denial by the appellant in his examination under section 313 CRP to a gravely incriminating circumstance is not sufficient to absolve him of the burden. No, cut that. No, of the burden cast upon him to absolve himself of the crime by giving an unsubstantiated and unproven statement that he was not that he was in Guwahati at the relevant point. What about that witness, single witness? That is a judgment. In the case of Sriracha versus Sriracha, the Supreme Court has held that conviction can be made on the basis of the testimony of a single witness. We'll argue with that. That's all I think. Yeah, anything else? Brother? Next, on a consideration of all, consideration, no, in view of the reasons stated above, we do not find any ground to interfere with the impugned judgment passed by the learned trial court. The appeal is accordingly dismissed. Sent back the TCR. Next para. In appreciation of the assistance provided by the learned amicus curiae, his fees shall be paid by the Assam State Legal Committee.
Point of raise is she,
Why? Oh, why is it?
evidence of PW1, relevant pactman. Because he was there while, after committing the crime, he came out immediately, was running.
But that is hearsay, no?
No, this is
Not
an
here.
exception to hearsay evidence, res gestated. Section 11 of the evidence. I'll leave it to your lordship. Otherwise it goes by.
No, you see, res gestae pertains to hearsay evidence.
Yes,
Okay,
exception.
yes. So out here, in fact, his evidence is not hearsay. His evidence is stronger, in fact.
Yes, my lord.
It's the-
Evidence of respondent number
Number
one,
one is
PW1.
PW1
Yes.
is better in.
Yes, my. So part of the same transaction, it is
Yes,
spontaneous.
Yes, it is not it's spontaneous. But that res gestae theory will not work here. Because res gestae will be like when it is hearsay evidence. Here it is not here. Can it be hearsay?
No, it's a part of
It's
this.
a part. He saw you running away.
Yes.
So
for
when
running
when you read it in line with the others, okay, you put one paragraph. Further, where we are talking about PW1. Now further, the chain of events with respect to the appellant being taken from the Belfort PS to his house and the appellant thereafter having been seen as running away from his house. Leads us to believe that. No, before that, from his house, and the fact that, and keeping in view the evidence of PW 4 and 9. Come on, lead us to believe that. The evidence of PW 4 corroborate the evidence of PW 4 and 9.
Evidence of PW one corroborates with 4 and
4 and 9. That the appellant had killed his wife with a knife.
citation will be
No, well, it doesn't
right.
fit in so easily. Hearsay will be if he has heard and then he makes evidence on the basis of his hearsay evidence. Here he has not heard. He has basically seen.
Seen.
He has taken him and saw him running out. So actually it's on a more stronger footing. It's more of a circumstantial evidence. It corroborates the circumstantial. With correction here and there, and hopefully